adjust their screen names for and make sure we have everyone in attendance, and we'll get started. Feel like the live stream is up and running. Everyone's identified with their party identifier. That just helps us stay organized here. I just want to view the closed caption here. All right, great. Okay, everybody ready? Let's get on the record. This is docket 137 CE 210, the ATC application we're calling Dodge County Distribution Interconnection Project. My name is Michael Newmark, the Administrative Law Judge for the PSC, and we are here on Zoom for the party hearing session. Letting in one more people. Okay. And so we have Zoom, we have the parties and commission staff connected to Zoom. We've made we're also live streaming on YouTube, and we've made that connection available for the public to observe the hearing. And if they cannot connect by internet, they can connect to Zoom through the telephone. And the instructions on how to do that. We're in our notice of hearing, and I'm displaying that on our screen share. So the YouTube video will become a recording, and it'll be housed in the Commission's hearings YouTube channel. And we'll also, that'll be an unofficial recording of the hearing. The official recording will be what we transcribe on the transcript with our court reporting service. I have someone joining us with the screen name CG Louser. Anyone recognize that name?
I'm guessing it's Chris Glauser.
Okay, and that's from the utility. We'll see if we get it right. Oh yeah, it didn't show up yet. Okay. And then Karen is also joining us. Is that could be ATC. We'll just leave it off for now and admit them. We did have a Zoom bomb on another, it wasn't on a hearing, but it was another meeting this week. So we're gonna avoid that if we can. But that's why we do have members joining or just observing through YouTube instead of joining Zoom. So just in the future, keep a note of that when you're giving people instructions about how to participate. And as you can see, it would be ideal to get people all connected to Zoom before we start, but sometimes it's not possible. I understand that. So we just take a moment here during the hearing to let people in. All right, so I sent out an email to parties and commission staff yesterday, kind of detailing our pre-witness process before we take our first witness. I don't have that in front of me, but from memory, I think I pretty much have the order of operations here. So first of all, we're on the record. Let's get appearances. I'll show you the service list we have currently on file. These are the contacts we'll use to serve the final decision and any other official documents in the case. So make sure that we have everyone correctly noted here. And we'll just go through the list on the record. Who do we have for representing American Transmission Company?
Brian Potts from Hush Blackwell and Alyssa Leroy, who is a little further down the list, or right below me, from Hush Blackwell, and then also Stephanie from ATC Neitzel.
Okay, got it. Thanks.
And I think that's all from a lawyer perspective.
Yes. Right? Okay, great. And for PQ Workma or Wormka LLC, who's representing them?
Morning, Your Honor. J.J. Rawling with Von Briesen and Roper on behalf of P&Q Warmka. And with us as well is Dirk Hausman, also on that list. And I believe that's from the attorney's perspective. And then Bob Bingen, I believe, is online right now.
Okay, I see that. So, so who was speaking there? Was that Joseph Rawling?
Correct.
There you are. Okay. I couldn't find you for a minute. I got you. Okay, great.
And
Yeah.
Pete Megenberg also for P&Q
Yes,
Warmth.
I see you there. Okay. Thanks. All right. So for PSC,
Sophia Rogers.
all right. And that's all our appearances. Thanks for that. So let's move on to the offered evidence list. We can do this off the record. I think for the most part, we're just going to be talking about getting the list in correct format or correct form. Make sure we have all the documents identified correctly. So just bear with me here. We'll get to the top of the page. So first of all, just want to know if I have reflected what's been offered in the record correctly on this document. And we're gonna be talking about the Guerrero errata later, but everything else in terms of how the list appears, did I put the right documents in the right place? Am I missing anything? Is there some mistake here? So that we'll talk about that first, and then we'll go into the comments if there's any questions about the refiling requirements. So let's start with the applicant. How does that list look so far?
It looks good to us. We double checked and I don't think you missed anything.
All right, good. Doesn't often happen that way, so I'm glad. I got one person joining us by phone, so we're off the record, just gonna make sure we get that person connected. I see we have someone joined us by phone. The number ends in 130. So I'm assuming you remember the public. If that's not the case, let me know. Just feel free to listen in. That's part of our instructions. If you can't connect to the live stream, you certainly can listen in on the phone. No need to unmute your microphone unless you're a party and need to participate as a party. So thanks for joining us. All right, so let's get back to, am I saying this right? It's Warmka, P&Q Warmka?
Correct.
Okay, great. So any issues with the offered evidence list?
None, Your Honor.
And commission staff?
We noticed that the docket number at the top refers to the wrong project. It should be
Okay.
210.
Thank you for that. I can't imagine me making that mistake nowadays. Appreciate it. All right.
Also, there was a rebuttal offered by Kirsten Biefeld, who I'm sorry, I should have included in the pre-hearing notifications. Katie Smith, her supervisor, is going to be substituting for Kirsten today and sponsoring those testimonies. But Kirsten Biefeld submitted a rebuttal. I'll find the CERF number.
Okay.
It's 546-273.
Okay. Don't see it. I can see it on the list. Let me
It's
give you that number one more time.
546-273. I see it on IRF, but it's not on your list.
Okay. 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 So that was filed on May 19th.
Yep.
Okay. Huh. I don't know how I missed that. Okay. So,
must not have enough to do and worry about.
so that was filed by
Befeld.
Befeld. Okay. All right. Okay, we got that. So let's see. So the list looks good. Let's now go into comments in terms of the refiling comments, just to conform the filings to the formatting that's required. Any questions there from the applicant? If you had any. Cummings was just the one naming of the of PQW. That's the only one I saw. Great. Oh, and Lemire. Yeah, pretty basic. Just show you the comments here. So just some basic formatting. Okay. And for PQW, I'll just make it easy on me. Oh, and also Mahaffey also had some, just to change the name of the party. Yeah. Okay. So how about PQW? Any questions on the formatting?
No, I don't believe so.
Okay. And staff had McDonald. Just changing a citation change into the PSC rules.
That correction is on its way.
All right, so what we do here is then the parties and staff have 3 working days to refile using these instructions. Anything else that we decide to change during the hearing, just so that the final version's got, is up to date and corrected for the commissioners to review. Right. Okay, so I think the last thing in terms of the list is so I'm going to pronounce, am I pronouncing this right? It's a where let me just tell me what the witness's name is or Arata Guerrero.
Oh, Guerrero.
Guerrero. Okay, Guerrero. I pronounce everyone's name wrong, so
I have the same problem.
people you're pretty used to that, but Guerrero. Okay. So we have the direct was filed on the filing deadline. Then we got our errata yesterday with some pretty substantial changes. Things that I don't necessarily consider errata. But actually I just wanted to, do I have the errata? This is the errata that was filed, changing the nature of some of the testimony by adding some words, descriptive words like avoiding interference with avoiding adversely interfering. So I think that changes the testimony in a substantive way, but also some other changes I couldn't really understand the purpose behind, like the full length preliminary. And then there's other change, like huge blocks of replacements. So I just wanted to go through those, which might be more helpful. I know we have a blackline version. I appreciate ATC doing that. We're on the record, right? At this point.
Oh,
Yeah. Oh, yeah, it's got on the record for this.
Okay.
Sorry about that. Yeah, so we're discussing the Guerrero errata, which came in last night or during the day. Sorry, it was filed on time, but it was surprising to me because of the nature of the changes, both the amount and the substance of the changes. So I did kind of give everyone an email with my comments about what was concerning to me, and showed some portions struck and other portions I had questions for. I'm just going to repeat this for the record. Just the first change to me seems substantive by adding adversely, or at least it's leaning towards a legal terminology. So I don't know. This seems like witness is just taking that a little too far in terms of errata. Full length preliminary, the next change that's offered, I just don't really understand what that means. And then the other changes, many of the other changes are dealing with, actually what the routes are and how long the lengths of different segments are.
Yeah,
That's
I mean,
a concern.
Your Honor, I can
Just let
explain.
me finish.
Okay.
That's fine. I'm just going to give you a preliminary what I'm concerned about. So and I guess the concern there is whether, the record is accurate in terms of, is this what's actually being proposed? Is that in the final application in the correctly stated in the application document, or is this changing what's being proposed? And then I know some of the changes, and they made sense to me that they were updating who the actor was. I know this witness is consultant from ECI, and I think the idea was to change some of the identity of the actor from was originally stated as ATC doing something and replacing it with ECI, which to some extent is reasonable. Other extent, it does kind of raise some issues that we can talk about. But I guess my preliminary question is just in terms of this testimony, if the information is in the application stated correctly, in terms of what the applicant did and the routes, the current routes being proposed, if that's already in the record in another form, because this is such a substantial change, and at this point, I don't think the witness could verify under oath the original version, given that the changes that are being proposed here. But the changes are substantial. I don't know if that's really a reasonable errata as either. So just my initial take on this is that if the information is already being provided in the application, we can just withhold this offer of evidence and rely on the application document without getting into confusion about who said what when and what are we changing and why. So I can hear from parties and commission staff about that and start with the applicant, of course.
Yeah, I mean, we're to give a little context here, when the schedule was originally set, we got 2 weeks to draft direct testimony, including one of the weeks which I'd identified as my vacation. And then when the witness reviewed this testimony before the hearing, it became clear that the record it would be better for the record to clarify which of these individual parties did what. The changing of the numbers is no different than any other errata. I think it's just updating the numbers based on data request responses or other things, although I'd have to check with the witnesses. There's no substantive difference in any of the routes. They're just clarifying. But again, in this case, which seems to be in a couple cases, the application was filed, then there were a bunch of data requests, and then a bunch of the numbers get updated through those data requests or change. And so the long story short is we don't have to put this errata in. The witness wanted to clarify things that I thought would be better clarified in the record. So basically the newer testimony is more specific and make sure all the numbers align with the updated data request information, but doesn't change any of the actual information in the record. So if you don't like this process, I guess, or it's too late, we're fine relying on the original version, although there may be some, or we could refile this with just the changes to the numbers, which is like the other witnesses had done, and not change the references to the parties and the other cleanup kind of stuff we did. Certainly weren't trying to throw a big wrench in anything. Just, it came to light in talking to the witness, and the witness felt more comfortable saying most of the big changes, like the paragraph things, are ECI versus ATC stuff. So I guess my thought was we'd file the errata, we'd send around the versions, and if anybody had objections, they could object and you'd rule. And if nobody had any objections, it's better to have the final conformed version of the testimony be as clear as possible for the record. That was my thinking. But again, if you're concerned about too many changes in errata, we don't have to do this. Is basically the long story short.
All right. PQW, any comment on this?
I don't have anything where I perceive there's an issue here. Testimony may change my mind, but from what I see so far, I don't have an objection or issue with it.
Okay. Yeah, I'm not expecting there to be that much more testimony on this. This is kind of, direct is really the bulk of what goes in the record for witness statements. But how about commission staff?
This, so commission staff hasn't had time to go through and confirm that it's, the information presented here is consistent, but hearing my colleague Attorney Potts's explanation and of the intention here, I would agree that it makes sense to get this corrected for the benefit of the record going forward.
Mm-hmm. Okay, so I just was curious because I know they said there were some changes made to the routes and they were done, and now this is updating some of those changes. But I mean, it looked like from the information that's being replaced, or the information that's coming in now as a replacement, says that the siding report was dated November 24th, 2024. So the changes are reflected as of December 24th, or is this new changes that are coming in or that were later than the direct coming in? I guess that's what was the timing on that?
That I don't know. We'd have to
Mhm.
ask the witness.
Okay.
Although I don't know if we're allowed to ask the witness. She's on right now. We could just ask her and she would know.
Yeah, that's fine.
Jaslyn, are you able to? I think he's talking about the page 9, but basically the December 24th information.
So the December 24th information is the latest report that I worked on for the routing and siding, and so that's what I'm referencing throughout this.
Okay. So that was available. I mean, I'm talking to the attorneys then. That was available before direct was due.
Presumably, yes.
Okay.
So it's a correction to what was in that report. Jaslyn, just to clarify, is that report in the record at December 24th, 2024? Do you know? You probably don't know what's in.
I don't know.
It was a data. Well, it should be. I mean, that's what.
Yeah, it was probably a response to a data request given the timing. But
Okay, but now it should be in the third revised version of the application document as well. That's
yeah, presumably.
well.
we
Let's
would
make
have
sure it
updated
is
the
because that's
application.
what the commission's going to approve. So So I mean, you want to make sure we have the proposal in the application. I've been keep trying to make sure we have an updated application document for the commissioners to approve or deny, but I don't think
Yeah,
we've denied them yet. So
I know we had to file a red line of the application every time for the data request, so I would presume that that's in that red line, but I have to go look, obviously.
okay. So, but just so you know, the way I want the record to read is that the final version of the application should be filed as application documents and then linked to the latest version of the application exhibit. So when the commissioners say, what does ATC want? They can say, well, where it is in the application, I'm going to get out the application exhibit. I'm going to click the link to that document on the application exhibit. I'm going to read what they want me to approve. So if it's not in there, we got to make sure it is. So I can give you the 3 days.
Yeah, well, I was going to say maybe because, we circulated a red line, but maybe it would be easiest if we gave everybody a day or two after the hearing to object. If they do, they can let me know, and then we could file something conformed by the third day.
What are we objecting to?
I just meant Miss Rogers noted that they hadn't had time to review the conformed or the red line. So I was trying to give the other parties the time to look at it, and just in case they had any issue.
Well, if you file something after the 3 days, that'll trigger a 3-day opportunity to object. So
oh, I see. Okay, so I'll just file it in 3 days, and then if anybody has an objection, there's already an objection process.
I'm just assuming you're requesting to add evidence. So then at that point, people can object. They have 3 days to object.
Okay,
But, do we
that
know what
makes,
we're doing here? I mean, we're looking at the application exhibit. We're
yeah,
making.
to make sure it conforms and is
Wait,
in.
wait, wait. You can't talk
Oh,
over the
sorry.
judge. Thanks.
So we're looking at the application exhibit. We're making sure it's got a complete listing of all the current documents that the ATC considers to be the application. And all those documents are linked to IRF as an application document.
Yes, we just filed one of those, a
Yeah.
revised version, so we'll check that one and make sure it has everything it needs to have.
Right, because I asked you to update it. So I want to make sure we continue that process, make sure we have the current versions updated. So, all right. So I guess I'm not sure why, if it's true that the information of on the routes was filed on December 24th, why we waited till yesterday to update them. And I'm sorry, I know people are pressed for time. I'm pressed for time, but we're really trying hard to keep all these cases straight and trying to keep them all complete and accurate. I need ATC to do a better job. I really,
And part of this is
why-
my fault.
there's no reason why you have 5 attorneys and 7 witnesses. Now, I respect you had scheduling problems. And when we made the docket, schedule, but we're pressed with many dockets going on simultaneously. With the resources of ATC, I just find that this is not acceptable, not to catch this before.
Yeah,
So-
and to be clear, and this is on me, I read your pre-hearing conference memo as saying if you have corrections to your direct testimony, you make them in errata right before, not you make them in the middle of the proceeding. And so all the other errata too, frankly, it's on me if that's incorrect. We could have probably filed earlier. When I looked at the pre-hearing conference memo, the process for fixing direct testimony says file errata whatever number of days before the hearing. So that's why we waited. I mean, this one is not that situation, but the other two were also that situation. So in the future, I will make sure on all the ATC dockets that we'll update it as soon as we know of anything. And can we just file errata at that point?
Sure. Yes.
Okay.
You can file as many errata as you want before the deadline for errata is the day before.
I see. Okay.
Okay.
So that's on me. I'm sorry, but that's not ATC's fault. That was my fault.
Okay. Well,
I mean, I'm ATC.
I don't see a difference there, but it's okay if you want.
Yeah,
If
fair.
you want to take the blame, that's fine. But like I said, there's plenty of people backing you up, and I hope everyone can take that opportunity to do that.
Judge,
Yeah.
I'm not sure that my witness is clear on I think we still might have to clear up whether this is the information that was reviewed for the EA. May I ask for my witness to just clarify what she might need to understand what might be a change or might be consistent with what she looked at? Jessica McDonald's is the environmental analyst on this case.
Sure. In other words, if we need this testimony in the record, is that what you're asking?
Well, I guess I'm unclear at this point if what's in the application, which hasn't yet been revised, is accurate. I understand that information was clarified in data requests, and that would have been incorporated into the EA. But I just want to make sure that we're on the same page, that there's nothing new here. Maybe
Yeah, I can answer that, I think.
Okay, thank you.
This information, as I can tell right now, obviously, was filed in December in response to a data request. The EA didn't come out till March or April. And in conjunction with every data request round where the staff has asked us to file a conformed copy of the application. So we would have filed a conformed copy of the application, I believe, whenever we filed that data request response. But regardless, it was certainly in the record way before the EA came out in this proceeding. So
Okay.
at least that's, again, I think as I understand Judge Newmark's process here, we're going to check the application to make sure what I just said is accurate and that the revised application exhibit points to the conformed most up-to-date information. And then we'll file 3 days after a conformed copy or the black line, I guess, of this direct. And then if anybody has an objection because they think we're putting in new evidence, they could object at that point. Did I say that fairly, Your Honor?
Well, I think in terms of the application document, that's where I'm giving you a chance to refile.
Oh, okay.
I mean, the black line, uh, 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 Guerrero Direct is, already been, shared with everyone. So at this point, I would think we'd want to have, well, I mean, yeah, I think we'd be looking at objections now for that. So I did want to mention, so it looks like the application document that's linked to the third revised application exhibit was filed on November 15th, 2024. So that indicates to me that that was right. That was December 24th was when the siding
Yeah,
report.
so we may need to file an updated conformed version of the application.
Okay. Excuse me, Judge, may I ask one more question of the
Yeah,
attorney?
go ahead.
So Attorney Potts, so are you've confirmed all the information in this errata it's consistent with the data requests that were provided in advance of the EA. Everything was provided in advance of that March date, and
Yeah, that's my understanding. It must have been in response to a data request, was that I'm assuming.
okay, yeah.
So it would have all been in the record. The commission would have had it. It's just that we need to update the final application exhibit, it sounds like, with
Okay.
these numbers.
I'm comfortable. Yeah, we don't need to confirm with Jessica. She's let me know offline that she's comfortable.
Okay, that's good. So I do want to just review. All right, so I think sounds like this although I think I've recognized the issues with filing this errata in its format on this late date. Hang on, let's go off the record. Okay, we're back on. Sorry about that. So this errata in the nature of the substance and just size of it is not appropriate for an errata filing. However, looks like the record would benefit and there's no objections to have it entered into evidence. I did think we do need a few statements clarified because, like I said, the original document now has been changed to so much that the witness couldn't reasonably verify that under oath. The new document, however, brings up some issues that I think clarifies the witness's position, but may raise some questions in terms of the evidence ATC is presenting. So I think the one that gives me the most concern is we're switching ATC, the ATC designator in many places to ECI, but then the statements that relate to ATC are not necessarily very definitive statements. It's just the understanding of the witness. So I think we need to see if we can have an ATC witness confirm some of those statements where the witness is saying that Guerrero is saying that that witness understands ATC to have done something, but if we have an ATC witness here today that can just testify whether that's been done or not would be useful for the record, so we don't have things kind of sitting out without explanation. So,
yeah, we can do that, Your Honor. That should be relatively easy.
All right.
And I'm going to go ahead and, while he's listening, ask Mike Cummings, I think, is the right person, and or Tim Lemire to look at this black line and wherever it says ATC to confirm that that was done. One or both of them.
Right, yeah.
And Tim goes first, so maybe it'll be Mike. Just because I don't want to have to force him to try to read this right now.
No. So let me point out a couple other areas here that we may need to clarify. That might be better just use my version. So all right, yeah, you're not gonna, well, we can do this off the record. Just so you know, if when you're citing a statute, just cite to the current statute, not to the act. So you'll see that Wisconsin Act 89, and there's not even a year on there. So it's just use the statutory citation. That's going to be cut out anyway, but I just want to let you know for the future.
Okay.
Yeah, I guess I'm not sure why we're changing the sections that deal with what the conclusions that the witness is coming to. I mean, I think they stated how they believe the project was reviewed and what they're presenting to the commission. They're just I'm not really sure why we need to change like those conclusion statements, but there's no objection to it. That's fine. There was a couple of places, like I said, where there was this might be the one. Yeah, this one you're replacing discussed in billings in direct ATC billings with completed by ATC. That's the route choosing the routes and discussing where routes were eliminated. I mean, Phillips does discuss that. Is that not accurate anymore? I don't know.
Yeah, I think that's accurate. I don't know why that change was made, but we can. I'm just assuming that Miss Guerrero wasn't, positive that the person was right, and so change it to ATC just to be safe.
In terms of her knowledge, that's fine.
Yeah,
We can leave it and
exactly.
just leave it the way it is.
I'm guessing, but
Yeah, that's fine. Yeah, so where there's like this example here, in my understanding, ATC conducted field analysis. That's where we'll have to have an ATC witness confirm that.
yeah. We're sending the black
Okay,
line to
yeah.
Mr. Cummings, and
All right.
my
Yeah.
plan. Oh, sorry. My plan is
go
to
ahead.
have him review the whole thing and then testify that, all the references to ATC doing, he confirms that was done, if that's okay with Your Honor.
Yeah, we'll do that when he gets on the stand. That's great. Okay, that's fine. So we'll accept the legal black line version. You'll need you'll need to file that. I don't think it's on Earth yet. So, but I do want to see, I want the changes noted for the commissioners to see how much was being offered at the last minute. Otherwise, that's good to go. I think we have everything settled now on the offered evidence list. Anything else I missed? Okay. All right. Well, I think we're ready to go.
Did you need that statement on the record
The statement of what?
about the offered evidence list?
Were we not on the record this whole time?
No,
Oh,
no, you said off the record.
okay. So we're back on
Just
the record.
Just this last bit. Go ahead.
Just the last. Okay. Well, we're on the record, and I'll say that any other issues with the offered evidence list? I didn't hear any when we were off the record. Okay, we're good to go. All right. Well, let's move on to witnesses. So we have ATC call its first witness.
ATC calls Mr. Tim Lemire to the stand.
Okay, I see you there. Raise your right hand. Swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, great. Go ahead.
Good morning, Mr. Lemire. Could you please state your full name for the record?
Timothy Aaron Lemire.
And are you the same Tim Lemire that filed direct and rebuttal testimony? Sorry, written pre-filed direct and rebuttal testimony in this docket?
Yes, I am.
And now that you're under oath, if I were to ask you the same questions that are in your written direct and written rebuttal testimony, would your answers be the same?
Yes, they would.
And Mr. Lemire, I have one quick question that I think there's been some discussions between you and PSC staff about potential use of a laydown yard that we wanted to put or make sure is in the record. Could you please describe what options ATC has with regards to using the laydown yard near the P&Q quarry?
Sure. The customer that is building the data center has some space that we could potentially utilize on their site to store materials as they start to arrive, including things like the construction matting. Those materials would start to arrive as early as this summer, and it would be the most schedule and cost benefit to lay those materials in matting down in those areas that the customer would allow us to use. The other option would be for us to store those materials at an existing ATC established yard and then retransport them to the project site after the order.
And if you were to use the customer's property as a laydown yard, would those areas already have been disturbed by the customer prior to their use as a laydown yard?
Yes.
So no new impacts would occur by ATC's use of the customer's existing property for a laydown yard?
No, we would be laying materials down in areas that are already established or will be in the future established by the customer.
And what's the overall cost difference between using the laydown yard or the customer's existing property versus transporting them from ATC's existing substation?
Our contractors are estimating it would be in the $1 million range to transport materials from other locations to the site after the fact.
Okay, I have nothing further, Your Honor.
All right, so cross-examination, we'll start with PQW.
None for me, Your Honor.
Really? Okay. And commission staff.
Yes, Your Honor.
Go ahead.
Good morning, Witness Lemire.
Good morning.
My name is Sophia Rogers. I'm the attorney representing commission staff in this docket. I have a few questions for you, and let's start with the laydown yards. Because this was a bit confusing, and I want to clear up.
Can we go off the record just for a second? Do we have a map on file that will give us kind of a visual of what we're talking about?
We could use the P&Q quarry map, which is an exhibit. That's probably shows it.
It's nothing that ATC's had already. Okay. So which one?
I think it's the number one, Bingen number one.
Right, we're off the record, I think number one.
Yeah.
Oh.
Okay, that'll be useful. Thanks. All right. Well, let's get back on the record. Yeah, if we could just identify this and and then move on with your questions, Attorney Rogers.
Okay, witness Lemaire, are you familiar with exhibit P and Q, Wormka LLC Bingen 1?
Yes, I am.
Okay, and this map sufficiently shows the laydown area that you were just discussing with Attorney Potts?
Partially. The light blue area is the substation pad that the customer is preparing for us. That one is identified as a laydown area in our application already. We would be asking if we could utilize it before the order would be issued. And then in addition to that, at some unknown locations yet, the customer is developing their own laydown areas for their construction activities. So it would be somewhere south and probably east of that location. They have additional space that they would be allowing us to utilize to lay additional materials down, areas that they are already planning on developing for their construction project.
Okay. And I'll just I can just explain for the judge's information that this is consistent with what we were informed by ATC, but we had only looked at the question of the before and after usage of the same area and not the additional area until today. So witness Lemaire, do we have a map in the record showing the additional area being considered by ATC?
We do not have a map in the record of that. We are working currently with the customer to determine which locations on their property would best suit us and their project. So we have not yet determined those locations. The answer of are we allowed to lay materials down there before the order is kind of the first step. If we are allowed to do that, then we would re-engage with the customer to figure out where those locations would be and then generate a map at that time. They have numerous locations across their footprint that they are going to be developing.
Okay.
So can I interrupt?
Yes.
I mean, is ATC requesting, or what's its position? This might be maybe a legal question, but for the attorneys, but what's its position in terms of what it's requesting of the commission regarding the laydown area? Is it, we're just talking about environmental review impacts, or?
No, I mean, so this is a strange one, and frankly, the issue here, and the company just wants to make the commission aware, is that if they can't use this already disturbed area, in other words, the customer's going to do a bunch of construction on the customer's site, it's going to be cleared, and they've said we can use it as a laydown yard, but obviously we won't have the order when that happens. And so we wanted to basically make sure that this was in the record so that if there was something the commission chose to do or the staff was okay with it, at least everyone would know what's going on and it would be very clear. We don't want to use a laydown yard that we haven't identified in the application, but this could basically save $1 million. So we thought it was in everybody's best interest to at least raise the issue in the hearing. If we have to do it without using this laydown yard, we absolutely can. And I don't believe it will change the cost estimate. It'll probably just be part of the contingency. But overall, you know, given the tight construction timeline here, we thought it made sense for the record to just, you know, put something in the record, and then the commission staff can decide, you know, whether they're comfortable with it, I guess. Because we're not asking for the commission to make a determination before the order. It's more of we just want to make sure we're, you know, working well with PSC staff and doing what the commission thinks is in the best interest of ratepayers.
All right, appreciate that. Okay, so what do you think, question for Attorney Rogers, what does the commission need at this point? Would sort of an estimated location map be
Yes,
useful?
Your Honor, we have a map that we've received informally from Attorney Neitzel, and if that's not completely if it's not fixed, I think having something in the record here to indicate that we're going beyond the original area offered, and maybe update as needed. Commission staff has looked at this question in terms of the before and after question, and as long as it's an area that we've considered in the EA, we're absolutely fine with using that for the purposes described in the application before the order. You know, the construction activities really don't start until later. We don't consider this to be beginning construction and requiring authorization as long as it's in that area, but going beyond that area, that's where we're not as certain. And so I think this can probably be resolved by providing those maps and consulting informally with staff between now and the decision. We don't have concerns, but and hearing that this is an area that's already been converted is assuring, but we haven't looked at this. Another thing that I want to find out from this witness, I'm sorry, Judge.
Wait. Yeah, go ahead.
I'm not sure of the cost estimate. I'm not sure that this whole extra area is needed, or if it's enough to just use, if it's possible to just use the planned laydown area as originally indicated, and that would save the 1 million. That would be much more straightforward. So I'd like to find out from the witness if there's enough space there to avoid that transport, or if this is just a matter of convenience and expanding the laydown yard from its original allocation. May I ask that question of the witness now?
Yes, go ahead.
Witness Lemaire, you provided a $1 million estimate for the difference in cost between using an identified laydown yard, identified or proposed as part of this application, compared to using ATC laydown yards farther away. Do you remember that?
I do.
Okay, can you explain whether you still see those cost savings if we don't look at any area beyond what was originally proposed in the application?
So the laydown yards proposed in the application, most of them were preliminary estimates of laydown yards where our contractors felt that there was an opportunity to talk to landowners. At the time, we did not have communication necessarily with the general contractor developing the site that the customer is on. So our intent is likely going to be to update the commission and update our application with new laydown yard areas before the order, regardless of the direction that we receive. The existing, the blue area that was included in our application would not be enough to fully cover the laydown yard needs to save those dollars that we talked about. We would need additional space.
I think that resolves the question. And can you confirm, witness Lemaire, that ATC intends or it has committed to communicating those additional areas informally to commission staff, and also providing updated maps on Earth?
Yes, if in the future, we will be working with the general contractor on the customer property to determine how much space they would have available for us. And then we would generate some maps based off of those discussions.
Okay.
And one more question for witness Lemaire. So you would provide that documentation, and you would consult with staff to ensure that no new impacts, that we agree no new impacts have arisen before using those areas, correct?
Yes, that is correct.
Okay. We're comfortable on this issue, Judge. If you have any more questions, I have another area that I want to clarify with this witness when you're done.
Yeah, I was just gonna suggest or strongly request that we mark that map Lemaire 1. So it'd be EX ATC Lemaire 1, so that we have a placeholder for it. I know that Attorney Rogers, you were talking about informally presenting things to staff, but I think since it's been on the record, we want to just get it placed into the record. But I think what I'm suggesting is that it be the map that was just discussed previously in witness Lemaire's previous answer.
Yeah, the only question I have is when will that happen? Because I think we're talking about time frame that might not make sense to have it be an exhibit in the record.
Because it'll be
I mean,
after the order?
no, because typically the record would close after the hearing.
Well, it doesn't close if there's a pending exhibit. I mean, it'll be open to receive the exhibit for sure.
So we would just need to get that exhibit in before the commission's decision.
Yes, that would be yes. And then I mean
I think that's fine. I think this is all going to happen in the next month.
yeah,
Is that
okay.
right?
Within
Well,
a month. Okay.
yeah. I think that's fine then.
Answers the other question I had. All right. So yeah, I mean, let me say I mean, IRF is available to people to file things. It doesn't close. So the fact that maybe this is after the order, if we could talk about it, but I think at this point it makes sense to make an exhibit because we've been referring to it. If that changes down the road, it can be a data request response or something else. But I think it needs to be, you know, it'll be filed on IRF in some form, but at this point it should be in the record as an exhibit.
Yeah, I don't foresee that being a problem. We should, unless Mr. Lemire jumps in and tells me otherwise, we should be able to do that in the next 2 or 3 months, which is should be plenty of time.
Great.
I do agree with that, Brian. Just one clarification, the existing map that we just looked at does not show most of the property. So the map would have to be expanded to show those laydown areas.
Yeah, I think that's the idea, is that it'd be a different map that shows this specific.
Okay.
Right. Okay. And you know, that was another question I had. If the witness could just, I wasn't following close enough or have missed where there's supposed to be a blue mark where the partial location of that laydown yard is on this map. Is that?
It looks green to me, Judge.
Aqua-ish, maybe.
Can you just give me a direction? Like, is it in the north?
It's kind of southeast central.
It's
The
right on
big rectangle.
Oh, okay. So let me just put the cursor on there. That's what you're talking about?
Yes.
Okay, that's obvious. All right, great. Thanks. So yeah, it looks green to me. That just could be my screen, but yeah, it's the big colored rectangle. And David is kind of superimposed on top of it. So okay. Thanks. That makes it much more clear what's going on here. All right, great.
Judge?
So any other questions, Attorney Rogers?
Yes, and Judge, just on this exhibit, we did receive a map informally, including the original laydown yard identified, and then superimposed, there was a hash mark area, and that was really helpful to us to see what the difference was. So we would expect something like that in the formal filing.
Okay, that understood?
Yes.
Yes, okay. All right. Okay, any other cross?
Yes, Your Honor. I have a couple more questions. One of them has to do with the archaeological review and the architecture and history review.
Okay.
And it goes back to witness Lemaire's direct testimony. Thanks for pulling that up. Witness Lemaire, at page 20 of your testimony, you discussed the confidentiality requirements for submitting this information. I'll wait for you to.
Page 20. Don't have a 20, is that, I can probably,
Apologies.
oh, wait, are we on Lemire or?
Lemire and looks like I don't have the right citation. I think I can go without the citation if the witness remembers discussing the confidentiality requirements. I just have a minor thing to clarify. Witness Lemaire, do you remember describing submission of these reports in your testimony?
I do not believe I'm recalling submitting the reports that you're requesting.
Okay, Judge, I apologize. I might have, I clearly have the wrong citation, and I might have the wrong witness. Could I request 60 seconds to try to find this?
Sure, sure.
Thanks.
And I might be able to help, Sophia. Are you looking for the
Yeah,
impact stuff?
No, not that stuff.
Okay, that's the
Did you
next.
say off the record,
Yeah,
Judge?
yeah, off the record. Just remind me to go back on the record.
I'll remind you.
Yeah, I'm not seeing, looking at archaeological studies.
That might be in our environmental
Yeah, Erica
witness.
Beeman, it's the one at the top.
Oh, okay. Sorry. This is a question for Beeman, then I apologize. Wrong person. I'll clarify with witness Beeman then. But I believe I have one more question for this witness. If I have my witnesses straight. Witness Lemaire, are you the right
Wait.
person?
Back on.
Yeah, back on.
Yes,
Thank you.
Debbie. Witness Lemaire, are you the right person to ask about easements or access agreements entered into for this case?
It would either be myself or our real estate department, Mr. Cummings.
Okay, I think I'll try you, and then I can always ask witness Cummings later. The commission received a comment a couple days ago from a Dorothy Naring. And this is a landowner who, Judge, would you like the IRF number?
I may have that here in the bottom.
Thank you. Okay.
Let's see if it's ends in 14. Is that?
Yeah. Yep. Thanks.
And I might be able to save everybody some time.
Yeah.
I think Mr. Cummings is ready to answer this question. I
Thank
don't
you.
know that Mr. Lemire has the background. I mean, you're welcome to ask him, but Mr. Cummings has investigated this and has some information to provide.
Perfect, great. So then I don't have any more questions for witness Lemire. I appreciate your time.
Okay. All right, any redirect?
Nothing from me, Your Honor.
All right, spare him.
Hmm.
All right, so let's call the next witness. No, thanks, you're excused, witness Lemire.
ATC calls Mr. Billups.
There we are. Raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Mr. Billups, can you please state your full name for the record?
My full name is Michael Andrew Billups.
Thank you. And Mr. Billups, are you the same Michael Billups who filed or caused to be filed direct testimony and one exhibit in this proceeding?
I am.
And now that you're under oath, if I were to ask you the same questions in that direct testimony, would your answers be the same today?
They would, yes.
Your Honor, I'd move to admit Mr. Billups' testimony to the record.
Okay, yeah, let me, so I'll just ask, is there any objections to that? The period to, time period to object is over, but so I'll accept that motion, but I can also receive for the record all the documents we have identified on the offered evidence list that we've reviewed here today. So they're in the record and can
Okay,
be.
so I don't need to move every time.
No, I usually I do that at the beginning, but so I appreciate you you moving in because I didn't say this before, but now that I have, yeah, all these documents are in the record, but I guess we'll just they're in, but they're pending verification and also the corrective filings that we've identified.
Okay,
So-
thank you, Your Honor. I just have again there's been a little discussion or confusion between the staff and I think Mr. Billups regarding some MISO and MTEP appendices. So I just wanted to clarify that for the record. Mr. Billups, there's been some back and forth between the ATC planning staff and the PSC staff about MISO MTEP appendices or data. Would you please clarify for the record? And we just want to make sure the commission staff has all the data they need.
Sure. So ATC submitted this project to MISO as target Appendix A for MTEP 24 last year in April. The cyclical MISO process it's actually an 18-month process. And the period in which this project was submitted was after the modeling for MTEP 24 was released to transmission owners. The modeling is released based on the appendix of projects that MISO has on file at the end of the preceding year. So MTEP 24 models would have contained projects that were in MISO's Appendix A at the end of 2023. So that was prior to this project's submission to MISO. So the annual reliability assessment facilitated by MISO and included in MTEP 24 Appendix D would not have included information relevant to this project because this project was not modeled in that set of models that were released in March, which was a month before we submitted this project as target Appendix A in April.
And is there anything else you want to clarify with regards to MISO's analysis of this specific project?
Sure, yeah. So once the project is submitted, it is subjected to stakeholder feedback facilitated by MISO through sub-regional planning meetings, a planning advisory committee, prior to being recommended to the MISO board for approval at the end of the year. So ATC performs our own study and documentation for this project. The project information is then sent to MISO for stakeholder input and feedback. So that process is handled by MISO, and it is facilitated at sub-regional planning meetings. So that would have been the process that this project went through at MISO.
I have nothing further to add. I hope that clarified the record. And I tender Mr. Billups for cross-examination.
Okay, any cross from PQW?
No, thank you, Your Honor.
No. And commission staff?
No, Your Honor.
Okay. So I just was curious, just in terms of the MISO documents, do we have all the information we're looking for that's been provided to staff?
Is the question for me?
Yeah, I guess so. Yeah, sorry about that.
No, that's fine. It's our understanding that
No, I mean, I might be able to help out here.
Okay, yeah.
I mean, my understanding is that I think the staff was under the impression that this project might be in the MTEP 24 appendices, but based on Mr. Billups' testimony, those appendices would only include projects that were submitted up to the end of 23. So basically, the request for appendices is not necessary or relevant because it doesn't include this project. I think is
I can clarify that.
I let the witness. He knows a lot more than me.
Go ahead.
Yeah, I think it's also a confusion about different appendices. So this project, as shown by Exhibit 1, filed by me, is that serves as that is the MTEP 24 report, which serves as a record of this project's inclusion in MTEP 24 and designated as Appendix A in MISO's portfolio of projects. The appendices that we were questioned about were the technical appendices. Those appendices are a record of the annual reliability assessment performed in parallel to this project's development and didn't really intersect with it. So it's a case of two different appendices, I guess.
Okay. That satisfies me. So anything else? No? Any redirect?
Me.
No redirect? All right. Thanks. You're excused.
The applicants call Devin Mahaffey to the stand.
Okay, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Mr. Mahaffey, and actually, could you please state your full name for the record?
Devin Robert Mahaffey.
Thank you, Mr. Mahaffey. And are you the same Devin Mahaffey that caused to be filed or filed direct rebuttal and surrebuttal testimony in this docket?
Yes, I am.
And if I asked you the same questions today, now that you're under oath, that are in your written direct rebuttal and surrebuttal testimony, would your answers be the same?
Yes.
I tender Mr. Mahaffey for cross-examination.
Any questions from PQW?
No, thank you, Your Honor.
All right, commission staff?
No, Your Honor.
All right. Because I just had one question just to clarify. It's just one statement that was made a number of times by the witness, but I do have an example of it. Just going to put it up on the screen. Let me give you the page for that. So it's Sir rebuttal ATC Mahaffey 3, and give you the whole question here, but it's the witness is responding to PQW's witness Bingen on page 3, and there's some concerns about which blasting activities and where they'll be. I think that's been on the record, but the response in terms of, so this question deals with does an ATC representative need to be on site during blasting operations? And the witness's answer does clarify that there'd be no need to have a representative on site in every instance. And because the answer then references this guide that we're talking about that was provided to the PQW on discovery, I believe. And it's exhibit Bingen 4, and I just want to get a better understanding of what ATC uses this for and how it can explain a little bit more detail about. It has guidance documents that these documents, the witness says, provides guidance and recommendations, not requirements. And then he goes on to say that ATC will work with the quarry to provide guidance on how to help the quarry ensure its blasting operations are safe. But this answer is helpful, but I guess I'm wondering, in terms of this guidance document, or how does that relate to what ATC's actual practices are? I mean, are all of its is this guidance document? How does it impact the guidance it'll actually give to the quarry? Is there a connection there, or is it it just doesn't seem to give us much substance in terms of what the ATC will expect the quarry to do in terms of its blasting operations if it can't cite back to the guidance document. Is there any clarity you can provide us on that?
Yeah, I think I can. So again, that guide is just a guide, recommendations on mitigation for blasting near ATC easements. We'll use some of the items called out in that guide, specifically some of those requirements, but I guess our intent is to work closely with the quarry and develop what actually is required. I think I know for one of the recommendations, it's to provide at least a 5-day notice of the blast plan so we can review. I think a lot of things will be a case-by-case situation, but again, our intent is to have this determined with contact numbers for who to call when blasting is planned.
Okay. Do you know if ATC ever uses that guidance document as a requirement for a quarry and say, or when there's blasting on near an easement, does it just say, this is the guidance document, we won't let you do it any other way? Or is it always a negotiation and used as something that can be, I think you know what I'm asking. So go ahead.
Yeah, I'm not aware how it's used on other projects with other quarries. That's probably the best response I can give.
You never worked with a quarry before?
Not a new quarry. We've worked with existing quarries where things are already in place.
So there's less blasting? Is that the difference?
Correct.
That's a yes? Yeah. Okay. All right. Okay. So that's something, when I see an answer like that, it just flags it for me, like, well, what is the document really? What's its real purpose and how is it used by the company? So, but the ATC is committed to, the way I hear you saying is ATC is using this document as sort of a touchstone, but it will be able to negotiate and be flexible with the quarry's needs.
Yes, that's correct.
Okay. All right. Any other cross?
Your Honor, just because you had raised it, I would ask maybe one or two questions.
Sure, go ahead. Just
And
introduce yourself to the witness, please.
again, this is JJ Rowling. Good morning. Represent P&Q Warmka. Question about that same section 9.0 that the ALJ recently asked you about. Do you have any knowledge of any restrictions that are more restrictive than what's set forth in 9.0 that you've used with quarries?
Not that I'm aware of.
All right, that's it from me.
Okay. All right. Any redirect?
I just have one quick redirect that might be helpful. Mr. Mahaffey, would that document we're all talking about, the guidance document, also apply when, for example, DOT does road construction and needs to blast?
I believe it would. I haven't had any experience with DOT projects that required blasting near ATC transmission lines.
Okay. That was all. Thanks, Your Honor.
Okay. All right. All right. Thanks very much. You're excused.
The applicants call, assuming Your Honor's ready for it, Chris Glauser to the stand.
All right. There you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Your volume's a little low.
I'll try to speak up, Your Honor. My
all right,
apologies.
that sounds better. Yeah, just speak.
Thank you.
Okay, let's go ahead.
Mr. Glauser, could you please state your full name for the record?
John Christopher Glauser.
And Mr. Glauser, are you the same Chris Glauser who filed direct testimony or caused to be filed direct testimony in this proceeding?
I am.
And now that you're under oath, Mr. Glauser, if I asked you the same questions in your direct written pre-filed direct testimony, would your answers be the same today?
They would.
I'll tender Mr. Glauser for cross-examination, Your Honor.
Okay, any questions from PQWs?
No, thank you, Your Honor.
Commission staff?
No, Your Honor.
Okay. And just a question for Attorney Potts. Which is the witness that could address those questions we had on the Guerrero?
That's the next witness, actually.
Okay, all right. Just didn't want to excuse them yet. So, okay, great. So no cross. You're excused, witness Glauser. Thanks.
Thank you.
ATC calls Ms. Beeman to the stand.
All right. Don't see you yet.
Oh, sorry. It's showing up here. I keep doing it.
There you go. It's touchy
Oh,
sometimes.
I keep undoing it. It's slow. Okay, sorry.
There you go. Yeah, just gotta get the rhythm here.
Apologize.
Okay, no worries. All right, I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Go ahead with this witness.
Ms. Beeman, could you please state your full name for the record?
Yes, my full name is Erica Louise Beeman.
And Ms. Beeman, did you cause to be filed or file direct and rebuttal testimony in this proceeding?
Yes, I did.
And now that you're under oath, if I were to ask you the same questions in your written direct and your written rebuttal, as those have already been revised in the docket, would your answers today be the same?
Yes, they would.
And Ms. Beeman, were you here earlier during the discussion of Ms. Guerrero's changes to her direct testimony?
Yes, I was.
And have you had a chance to review the changes Ms. Guerrero has proposed to her direct testimony?
I have not, Attorney Potts. I thought you mentioned Michael Cummings.
Oh,
address.
Yeah, I did, although I think that might be the wrong witness. I think you're probably the right witness. So I guess there's
I can
two-
try.
Yeah, there's
Okay.
we could either can we I guess Your Honor, there's one of two ways to handle this. One, I think, is we could just go through them if you know where they are and ask her, or we can recall her at the end of the witnesses and give her some time to read it. Either way.
Okay, well, why don't we recall her? I think the main, if this is the right witness we're talking about, the main concern is where currently witness Guerrero is explaining in the testimony that that the witness has an understanding of what ATC has done. We just want to confirm that that's actually what ATC has done. So there's a number of places now where the testimony has been changed from saying ATC did this to I understand ATC did this. So that's
if we're going to recall a witness, it would probably be easier to recall Mr. Lemire, who's the overall project manager and who can testify generally about everything that ATC has done, rather than Ms. Beeman, who is just the environmental witness. Not that there's anything wrong with being just the environmental witness, but so I thought her or she would be easier, but if we're going to recall somebody, Tim Lemire is probably the easiest because he's the project manager for the whole project.
Yeah, I'm pretty sure this relates to, well, it's routing and siting. So that's
what I mean, that's both environmental and the whole project routing and siting team.
okay. Well, as long as it's someone who's aware, can answer the question, that's fine.
Okay, so let's Ms. Beeman, I think you're probably off the hook, and hopefully Mr. Lemire is, he's probably cussing me under his breath, but it knows and is ready. So with that, I don't have any additional questions for Ms. Beeman.
Okay. So is there any cross for the witness? I'll start with PQW.
Nothing for me, Your Honor.
Commission staff?
Yes, Your Honor.
Okay.
Good morning, Witness Beeman.
Good morning.
My name is Sophia Rogers. I'm the attorney representing commission staff. And I have just a clarifying question for you arising out of your direct. So Judge, this is the archaeological question that I asked the wrong person earlier. So in Witness Beeman's direct at page 20, I'm about to ask her about lines 7 through 16 on page 20. Witness Beeman, do you recall your discussion about the confidentiality requirements applicable to the archaeological review and the architecture and history review submitted to the Commission's Historic Preservation Officer?
Yes.
Do you need a moment to read through this paragraph?
Just a minute.
Yeah.
Would be great. Okay, thank you.
So you noted that the documents had been provided under separate cover. That's at the end of, that's on line 16.
Mm-hmm.
What did you mean by under separate cover?
I believe that just means that the redacted copies were provided separately, separate from the application.
Okay, and so just to confirm, those reports were submitted to IRF as part of the application, right?
I would like confirmation from Attorney Potts. Yeah, if possible.
And Attorney Potts, I believe that they were. I'm just trying to clarify for the record that so that there's no confusion here as to whether they were separately, but Exhibit ATC Application Appendix F contains public and redacted versions of these reports, and we're satisfied that they're complete. I just want to eliminate any confusion.
Yeah, it was my understanding that they were filed.
Um,
And that
So-
is what is meant by that, yeah.
okay, so witness Beeman,
last
there's
time.
nothing additional that was provided to the historic preservation officer that wouldn't be in that application filing, correct?
Correct, nothing additional.
Thanks for clarifying. Okay, and we'll have some clarifications to the Guerrero errata later. I don't need to ask anything here, so no further questions.
All right. Any redirect?
No redirect, Your Honor.
All right. Okay, thanks. You're excused.
Thank you.
ATC calls Miss Guerrero to the stand.
There you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth. Your volume's a little low. Maybe speaking up or using earbuds. Is that? Maybe that's the issue.
Hello?
That's better. Try just say a couple more things and see if test or
I
something.
can speak a little louder. Does that
Okay,
work?
that's
Okay.
sounding better. Yeah, okay. Just want to make sure we can hear you. All right, so let me swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
Okay. Go ahead with the witness.
Good morning, Miss Guerrero. Could you please state your full name for the record?
Yes, my full name is Jaslyn Genevieve Guerrero.
And are you the same Guerrero who filed or Cosby filed direct rebuttal and revised version of your direct testimony that we've been discussing today?
Yes, I am.
And if I were to ask you the same questions that are in your direct rebuttal or I'm sorry, your revised direct and your rebuttal today, now that you're under oath, would your answers be the same?
Yes, they would.
I have nothing further for this witness.
Okay. You cross from PQW.
No, thank you, Your Honor.
And commission staff?
Yes, Your Honor.
Okay.
Would it be possible to pull up the errata?
Oh, yes, sure. Yes. So I have the black line version too.
The black line was great. Thank you.
Okay, that'll work. All right. Sure. Yes, I think we're there. Go ahead.
There was a phrase used, I think, it was just as needed, a modification made, to describe the, field reports conducted. And perhaps this is something, ATC's own witness Lemaire can address, but I wanted to know what you meant by the as needed, modification, and I'm sorry. I'm just looking for it. I apologize. One moment.
I don't see that as need.
Thought it was in here. I might be wrong. I'm just confirming with staff. We
What-
thought we saw something new that we wanted to ask about. I'm sorry.
What was the topic?
On the field, I thought it was the field reports. Sorry, we only got this last night and haven't prepared a great question. I just wanted to confirm one wording thing I thought, but I'm still looking for it. I think we can, if it's there, we can ask it of witness Lemaire.
Okay.
Sorry, no further questions.
Okay, that's fine. So I don't think there's much redirect we need, so you're,
I'll redirect your honor.
yeah, thanks a lot. All right. We'll take the next witness.
ATC calls Mr. Cummings to the stand.
You can turn your screen on.
I am trying to. Can you hear my
Okay.
volume?
Yeah, you're coming in loud and clear, but we don't see it yet. Let me see if I can.
There we go.
Okay, good.
I'm sorry.
You're good. All right, excellent. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Mr. Cummings, can you please state your full name for the record?
Michael John Cummings.
And Mr. Cummings, are you the same Michael Cummings who filed rebuttal? Sorry, who caused to be filed or filed rebuttal and surrebuttal testimony in this docket?
Yes.
And Mr. Cummings, if I were to ask you the same questions that are in your written rebuttal and written surrebuttal, now that you're under oath today, would your answers be the same?
Yes.
Mr. Cummings, there was one issue identified by the staff, attorney Miss Rogers, earlier today regarding the public comment made by Dorothy, and I'm going to forget her last name, but there it is, Naring.
Naring.
Yeah. Are you familiar with this comment?
I am.
And would you like to provide a little more background on what occurred with this landowner?
Yes, I will. So we sent out voluntary survey permissions to enter properties on October 28th of 24. Ms. Nearing returned hers. Unfortunately, we didn't put an expiration date in the document. So Ms. Nearing did return hers signed and included January 31 of 25, which means it would have been approximately 2 months of survey permission. So she sent it back. We then found out that we sent out some of our survey permissions that didn't have an expiration date filled in. So we received hers back, and then once we found out that these were not filled in, we sent out a new set of information to those that we found out didn't have the expiration date included. Unfortunately, Ms. Nearing did not get entered into that group. So we've made some mistakes. So she felt that she signed hers and sent it back, which she did. And we felt that we sent her the updated version, which she never received. Hence, we have an issue. So we've been contacting Ms. Nearing, trying to get this information from her when she said she's already completed it. That's where the whole confusion started. It was brought to our attention on Wednesday when we saw the report after the public hearing. And hence, we have reached out to Ms. Nearing saying that we apologize that we did inadvertently leave her off the follow-up mailing that would have corrected the mistake. We did pay her as well. We sent her a check out immediately because we know that we didn't pay her because we were waiting for completed documents that she never received. So that was the confusing mess that I got to the bottom of once we found out that we hadn't paid her. And we apologized to her and sent her a check. In the meantime, we are going over every one of our files to making sure that everyone else is taken care of correctly. And to our knowledge, we don't have anyone else that is in the same situation.
I have nothing further, Your Honor.
Thanks. Can I just jump in with a couple of clarifying questions?
Yes, sir.
You just referenced our report, and I just wanted to know what you meant by a report. What were you thinking of?
A report, I was probably referring to our survey permission. Or I could be, I don't have the context, Your Honor.
You said you reviewed it was after, I think the time frame was after the public hearing. You reviewed the report, and then I think the next thing you were talking about was sending her the check.
Oh, the report being the information that came out of the public hearing that I was made aware of by our public relations folks that were at the hearing.
Okay, so a report is created by ATC about what happened at the hearing.
Yes, yes, sir.
Okay, I wasn't aware of that. All right, thanks. And so the way I understand it is that the agreement went out to this landowner without an end date, and the landowner filled in a date. The second mailings that were sent out that are, I guess, to my understanding, they're the correct versions. Do they have an end date?
Yes, they do. And that date is January 31 of 2026.
Okay.
So therein is the other piece that I probably should have explained. So I'll just assume that our survey permission folks took a look at the documents, and on some of them it said January 31, 26 expiration. On Miss Nearing's, because she filled it in of January 31, 25 expiration, hence they felt that they had rights to be on her property. And as she wrote, we did not have rights because we were beyond the January 31, 25 date.
Okay. And just for background, what's being granted with this permission? Is it?
Yes, sir. The survey permission allows our surveyors to get out there and stake where the right of way will be, so that they can do, and our environmental people take a look at the corridors, etc. So they're giving us permission to get on their property to do those types of observations.
Okay. So it looks like, according to this comment, the landowner feels that ATC entered her property after January 31st, 2025, and therefore did so without authorization. Is that your understanding?
Yes, sir. That's what I read. And my explanation was because it should have said January 31, 26. But she filled in the January 31, 25, and we tried to get her a new document that we didn't perform.
Right. Well, she put in what she wanted to put in, and it was just different than what you thought was there.
Yes, sir.
Okay. So what's occurring now on the property? What is ATC doing at this point?
I cannot answer that, sir.
Okay.
Tim Lemire probably would be able to answer that one better than I.
Okay. I mean, at this point, do you think, or yeah, I guess you're the right person to ask. At this point, is it your understanding that ATC does not have authorization to enter the property for surveying?
Based on the expiration of January 31, 25, no, we probably do not.
Okay. Is it planning to enter the property in the future for purposes of surveying?
That should be completed, sir, to my
Okay,
knowledge.
so it has no plans to enter the property for purposes of surveying.
I can't definitively answer that. I don't know the schedule for the surveyors, but maybe, again, Tim could shed light on that one.
Okay. Will it seek permission with a new agreement before it enters the property for purposes of surveying?
yes, that would be the correct procedural move if in fact we do need to enter it yet.
Okay. All right. So I'll leave it up again. Any other questions for the witness?
Yes, Your Honor. Oh, I'm sorry. This was direct. Apologies.
I don't have any further questions. I'll tender Mr. Cummings for cross-examination.
Okay. All right. Yeah. Now I'm confused. Any cross?
Yes. I think I may have done that already, and then Mr. Judge Newmark went.
Oh, he went first.
That's okay. Let me just ask again because there was a lot of testimony there. So any cross from PQW
No, thank you, Your Honor.
and for commission staff?
Yes.
All right. Any redirect?
No redirect. Your Honor.
Wait. We do have cross.
Oh yeah. Go ahead.
Yes, that's right.
Good morning, Witness Cummings.
Good morning.
I'm Sophia Rogers. I'm representing commission staff in this docket. I wanted to ask you about the agricultural impacts of the project. In your rebuttal testimony, you responded to DATCAP witness Kirsten Biefeld's route alteration proposal. Do you remember responding?
Yes, ma'am.
And in her sir rebuttal, witness Biefeld responded back to you. So actually, sorry, Judge, I misled you there. Can you pull up staff witness Biefeld's sir rebuttal? Thank you. So witness Biefeld responded back to you in her sir rebuttal at page 2. Did you have a chance to review this?
Yes, I'm trying to get the screen back up so I can view this document. I'm sorry.
Take your time.
Standard. Okay. I have it now.
Great. And are you forgive me, but did you say already that you were familiar with this testimony?
Yes, specifically where are we?
We are
Is
at,
this on page 2? Okay.
yeah.
Okay. All right.
So
Yes,
generally,
I am.
okay, thank you. So as an alternative to a route alteration, witness Biefeld at line 6 here proposes some mitigation measures to reduce impacts on ag land.
Yes, ma'am.
Did you have opportunity to consider those proposed order conditions?
Yes, ma'am.
And can you please comment on the feasibility of those conditions?
Yes, ma'am. When we sit down with the landowners, we definitely, because we haven't been on the property and talked with them about where specific things might be located, that being drain tile, probably the most predominant, and agricultural purposes, and tubing and direct waterways, etc. So we definitely talk with them at the outset so that we understand their property better before we get on there and start to do, matting, construction, etc.
I'm actually not talking about the notification one that's up on the screen here. I was, if you go up to page 2 and 3, are responsive to the point about the Zimmerman Living Trust lands.
Okay.
Alteration.
That one. All
Yep.
right.
And then
I'm
if
sorry.
you go, no, it was unclear. Judge, if you can go down to page 3, those bullet points are proposed.
Yes. Yes, ma'am.
Okay. Could you specifically respond to those, please?
We talked about those as a team and we're okay with those considerations.
Great. So ATC.
For the 4 bullet points.
Okay. No feasibility concerns there from ATC.
No, ma'am.
Great. Wonderful. Just confirming I don't have anything else for you.
I just wanted to clarify, are those bullet points specific to the Zimmerman Living Trust land, or is that for all land in the project area?
Well, our witness substituting for Biefeld can expand on that, but my understanding is that it would apply. It's the way that it's written is it would apply to everyone, but it's specifically merited here because of the concerns raised by the Zimmerman Living Trust, which makes up a huge portion of the ag land affected. I think
Okay.
it's the majority. And so the idea was, if we can't get them an alternative route, at least order these recommendations.
So let me just ask the witnesses if you understand these conditions, the bullet point conditions to apply to all ag land. Is that still, is ATC still in agreement with those?
I was looking at, or we were looking at them specifically for the Zimmerman property.
I had a feeling that just the way it was worded, it may be confusing that way. So yeah, if you need a minute to think about that, or if we need to.
In a general sense, we're going to restore whatever we've displaced or damaged on a high level. They go into specifics here that apply to their property that may or may not apply to all properties. So in my opinion, it probably would apply to most properties. I can't say all, but I guess I would also allow Tim, project manager, to weigh in on that, whether it's across all.
Okay. So we got a maybe from you, and we'll check with Tim and see. All right. Anything else to add, or that's?
No, that's fine. Thank you.
And witness, anything else to add on that, or is that your statement?
That's my statement, sir.
Okay. You just look like you're thinking. So make sure you get a chance to see
I am thinking, but
you're just not speaking. You're a good witness. You're thinking.
it's hard to put a blanket over everything. So
yeah, I thought that might be the case. Okay, well, I'm glad we at least got that clarified. I don't know where that leaves us, but at least we know where we stand. Okay. Any other cross? Okay, let's do redirect.
No redirect, Your Honor.
Okay, that's good. So let's excuse you. Thanks very much, and we'll move on.
The applicants have now called all their witnesses. However, we would like to recall Tim Lemire to answer some of the questions regarding Ms. Guerrero's testimony and anything else that's left over.
Throw it at him. Yeah, we'll throw it. Great. Okay, I think your screen's warming up here. See you there, but I know you're there, but I don't see your face. So something's going on.
Are you looking for my face?
Yeah, you might have do you have a hard block on your a physical block on your camera?
How about that?
There you go. Okay. Get your thumb off the screen. We'll be good. Let's see. I probably need to let's get that black line Guerrero testimony up. And so we're recalling you, witness Lemire. You remember you recall you're under oath, correct?
I do.
All right. So did you want to take this Attorney Potts?
Sure, I can.
All right, yeah, go ahead.
No problem. So Mr. Lemire, earlier during the proceeding, there was some discussion about Ms. Guerrero's direct testimony and specifically the revisions that were made to her direct testimony. Do you remember that discussion?
I do.
And have you had a chance to review the black line of Ms. Guerrero's revised direct testimony?
I was skimming through it while listening to testimony, so I've got some of it, Brian.
Okay. And have you looked at the places where the statements are what ATC did versus what ECI did?
I've looked at many of them. I can't ensure that I captured all of them skimming through.
And the ones that you did review, were they accurate as to what ATC performed?
Yes.
Was there anything that you saw in Ms. Guerrero's testimony where she designated something as ATC having completed that you do not think ATC completed?
Not that I saw.
I guess I have nothing further, Your Honor.
Well, I do see two, at least, instances where the witness, Guerrero, is flipping the actor in the testimony from having stated that ATC did something to just being the understanding that ATC did something. So the one that stands out is page 6, the lines 1 and 2, where it's testimony now is, however, my understanding is that ATC conducted a field analysis to determine if the potential routes would conflict with any natural features, structures, and any other obstacles. So I just want the witness to confirm that ATC did in fact conduct that field analysis.
Yeah, yes, we did. We had a number of team members from ATC as well as our construction alliance partners.
And Your Honor, just to clarify the record, I think you said page 6, but that was page 8.
Okay, thanks. Yes, you're right. Look that around. And oh, this is in testimony. But this was part that was taken out. I think let's just, since we have the project manager here, let's just confirm that and I first of all, I guess, Kev, have you reviewed the adjustments to the testimony with respect to the length of the segments and where they meet in terms of the mapping of the segments that's discussed in the testimony? I got a page of that on the screen here.
I have not reviewed that thoroughly.
Okay, and the other place where the witness Guerrero makes the changes the confirmation of the testimony here is page 16, line 7, where it now says talking about whether the routes will unreasonably interfere with orderly land use and development plans. The witness now says, yes, it's my understanding that ATC reviewed and accounted for the publicly available land use plans as part of its initial project research. And it goes on. Can you confirm that ATC did that review and accounting?
ATC has a very experienced group of individuals that each have different functions with the routing and siting effort. And I do know that current land use and zoning were all taken into account by those different areas. I cannot validate who may have reviewed local future zoning plans and things of that nature, other than those documents were made available.
So you provided those to your staff or the people, other people working on the project to do that review?
So our routing and siting team, led by ECI Routing and Siting, had regular meetings where we went through the routes and discussed the pros and cons and the current land use. In those meetings incorporated environmental, real estate, construction, and all the different aspects of those properties. Constructability would have been taken into account. And we have a very robust mapping and GIS system where there's a lot of different information available to team members to help them make their decisions.
Then I don't know if it helps clarify anything, Your Honor. I believe the land use plans are in the application too, in an appendix themselves. So
Yeah, I know they're part of the application filing requirements, I believe. So we would expect to see the documents, but I guess I mean, the testimony is what it is at this point. I don't know if we have an exact answer to that question, but I mean, the answer that's been presented in testimony isn't false, and I think that's fine. I don't know if we have a complete confirmation, but that's all we can get today. That I'm comfortable with that. So okay, I think that's all I have.
yeah, I don't have anything else for Mr. Lemire. If Ms. Rogers or somebody else has any follow-up. I know there were a few deferred DAT cap order point.
Right.
What?
Yeah, we need to review that too. Okay, any other questions for this witness with respect to the revised testimony?
No, none from me, Your Honor. Thank you.
Okay, commission staff?
Yes, Your Honor. So the first question that commission staff has, it arose out of witness Guerrero's errata, but it actually goes back to the original application. So we can withhold it if there's an objection to going all the way back. It's not something that we asked in direct, but it's a pretty simple clarifying question.
I don't have any objection. Go ahead.
Well, ask it first, but yeah.
Yeah, fair enough.
The question,
With that, assuming what you say is accurate, I won't.
Judge, if you don't mind pulling up the application, we were looking back at the discussion of field surveys and the application and had a question about section 6.4.1.
Okay, so we're talking about the application in chief?
Yes.
Okay.
It says page 59 of 90 at the bottom, but I'm sure the PDF is different.
I'll find it off screen so you don't have to watch. So 51 of 90, you said?
59 of 90. And it's section 6.4.1, invasive species, disease-causing organisms.
Okay, I think we're there.
So thanks, Judge. At the top of witness Lemire, is it Lemire or Lemire? I'm sorry.
Lemire.
Lemire. At the top of section 6.4.1, there's a caveat. It says where accessible. Can you just clarify what that phrase means in this context of the field investigations?
Yes, I can clarify what I believe that means. Erica Beeman would be probably the better witness for this question, but I believe that means if we had access or permission from the property owners to access their properties versus if it was close to the roadside or if we already had an existing easement or if we had the voluntary permissions.
Okay, that's fine. Thank you. And then I think we needed to go back to the Dorothy
Right.
narrating comment. For that one, witness Lemire, did you hear your colleague? That was, I think, witness Cummings who took this originally. Did you hear his, did you follow that line of questioning earlier at this hearing?
Yes, I did.
I think the question that witness Cummings wasn't able to answer was just what the plans were, whether it was necessary for ATC to enter this property in the future. Can you clarify that question?
Yes, so we do not have any, I do not believe we have any immediate needs to access the property again. If we do need access in the future for structure staking or for surveying different things, we would institute a new agreement with the landowner.
Thanks. The other one for you was the DAT cap question. Did you hear the line of questioning arising from the Beefeld sir rebuttal testimony?
Yes. Sorry.
There were 4 bullet points in there. I think it was page 3, Judge. Have you reviewed those 4 bullet points that are suggestions for the commission to consider ordering as conditions of approval here?
Yes.
And the way that DAT cap staff has presented this, these would apply, these aren't narrowly restricted to the Zimmerman Living Trust. They're written as order conditions that apply to the whole area. Witness Cummings offered that ATC would commit or had no objections to these order conditions. First of all, could you clarify your understanding of the order conditions? In other words, have you considered them just narrowly for the Zimmerman Living Trust, or did you consider them for the entire area?
We were namely considering them for the Zimmerman Trust, but we don't have any concerns with having those 4 bullet points apply to the extent possible to the rest of the properties. I just cannot validate 100% that there won't be a situation where we're not able to meet all 4, and we would work with the property owner in that situation.
So is it fair to say that ATC does not object to these proposed order conditions with a modification to add to the extent practicable? Or I'm sorry, what was, I'm not sure exactly what your wording was, but something to that effect would be agreeable to ATC?
Yes.
Okay, great. Is there any specific phrase that, well, I'll leave that to the lawyers, I guess. I think I understand the meaning. So no further questions from staff.
Okay. So any redirect?
Nothing for me, Your Honor.
All right. That's all of ATC's witnesses.
Correct.
And I think we have all the information we need from ATC. We can move on to intervener, commission staff. Do we want to break for a few minutes before we press on?
I wouldn't mind using the restroom.
Okay, that was on the record, so there we go.
I'm okay with that.
Okay, good. Yeah, you wanted that on the record, didn't you? Okay. There you go. Okay, well, yes, nature calls on the record, we can answer. So we can take a half an hour, give people a break if that's okay. So we'll be back at 20 to 1. Okay.
Thanks, Your Honor. What did everyone have for lunch?
Leftovers.
Salad in the fridge.
Nice.
But if you ask the judge, he knows what I probably had.
Oh,
You always
boy.
have the same thing?
When we do public sessions, yeah.
Yeah. Almonds.
Almonds.
Almonds, eggs, cucumbers, the easy things
Oh,
to
right.
eat.
You're a health nut. I forgot that.
I was gonna say
Um,
it's classified. We go up to closed session to discuss this.
Yeah.
I never ate eggs before. I didn't eat eggs for a year and a half, and now I have those as my protein.
Impressive. All right, so we have everybody back. Everyone we need anyway. So we're gonna press on with the PQW witnesses and then commission staff. Let's call our first witness from the intervener.
Thank you, Your Honor. Intervener PQ Warmka calls Pete Mogenberg.
Okay, I know he's connected. Don't see him yet, though.
Okay, I'm here.
Okay. We just need to get your screen on. I don't think it is running. I just don't see you. Hang on, let me see if I can
I can see him.
Can you wave, Mr. Megenberg?
Oh, there we go. Perfect. All right, well, just keep using that hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Mr. Megenberg, can you state your full name for the record, please?
Peter Allen Megenberg.
Okay. And are you the same Peter Megenberg that filed or caused to be filed a set of direct testimony in this matter?
Yes, I am.
And did you also submit an exhibit or cause to be submitted an exhibit in this matter as well?
Yes, I did.
Okay. And now that you're under oath, if I were to ask you the same questions that are set forth in the Megenberg direct testimony, would you answer the same way?
Yes, I would.
And do you have any changes to make to the exhibit that you submitted?
No, I do not.
Okay. And briefly, that exhibit is what?
The exhibit that I submitted is an appraisal report on a ongoing quarry operation in the town of Trenton, Dodge County, Wisconsin.
Okay. Mr. Meg, actually, at this time, I would tender Mr. Megenberg for cross.
Okay. Yeah, all those documents are in the record. We'll just expect the filing corrections in 3 working days. So any questions, any cross from the applicant?
Nothing, Your Honor.
Okay, from commission staff?
No, Your Honor.
Okay. Okay, hearing no cross, no redirect. That's all we need to do. You verified the testimony, so you're excused.
Okay, so I'm not going to be recalled today.
I don't anticipate, so Your Honor, to interject, but if Your Honor is okay, or the typical process here, if it's all right if Mr. Megenberg be excused, I'd appreciate it.
I believe he can be excused. I don't think anyone has cross, right?
Fine with the applicants.
Yeah, I mean that's fine. No one has cross, so I think that would be fine. Yes, he can be excused.
Okay, very fine. Okay, thank you.
Mm-hmm.
All right. Next, Pinky Warmka would call Mr. Bob Bingen.
Okay. Okay, there you are. Yep. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
All right. Go
Mr.
ahead.
Bingen, excuse me, Mr. Bingen, would you state your full name for the record?
Robert Anthony Bingham.
Mr. Bingen, you submitted a set of direct testimony and rebuttal testimony in this matter, right?
Yes.
And you also submitted a number of exhibits, that's correct?
That is correct, yes.
Okay. First to the testimony, for both the direct and the rebuttal. Now that you're under oath, would you answer any of the questions set forth in the direct or the rebuttal differently than you did there?
No, I would not.
And then briefly, the exhibits. Can you run through exhibit 1 for us? Did you cause that to be prepared or submitted?
Yes, I did.
Okay. And can you just identify what that is briefly?
It's a evaluation of reserve estimates and reserve losses relative to the two proposed routes.
And I'm talking about Bingen 1, PQW Bingen 1. That's what you're referring to?
Yes.
PQW Bingen 2.
Again, these all were related to reserve losses, everything that we submitted, and quarry operations.
Okay. Well, let me pull you directly to the one. Do you have the one up on the ERF? Perhaps they could pull that.
You're looking for Bingham 1?
Yeah, let's pull Bingen 1 first, if that's all right with the court.
Yeah.
And can you see that, Mr. Bingen?
Yes, I can.
Okay. And that's Bingen 1, and your description of that is?
That is the description of our existing quarry plus the 65 acres directly to the east of it that has been permitted for continued quarry operations.
Okay. And then going to PQW Bingen 2. You see that, Mr. Bingen?
Yes, I do. That is a suggested berm construction that we submitted to ATC.
And Bingen 3. Thank you, Judge. Let me scroll down there. Do you see Exhibit 3?
Yes, I do. That is relative to our quarry expansion and our reclamation plans that we've got for the resultant quarry.
And you also submitted a couple more exhibits. What is the origin of Exhibit Bingen 4 and Bingen 5?
I believe those are rebuttal. Oh, well, maybe. Yes.
Did you obtain those through discovery?
Yes.
From ATC?
Yes.
And that's true for 4 and 5, correct?
That is correct.
With that, I would tender Mr. Bingen for cross.
All right. Any questions from ATC?
Yeah, we just have a few questions, Your Honor.
Okay.
Most to clarify the record. And I'm pretty sure we're going to need Exhibit Bingen 1 with the map. So I'll give you a little heads up on that. Good afternoon, Mr. Bingham. My name's Brian Potts. I'm here today representing American Transmission Company. How you doing?
Good, I think.
So I just have a few clarifying questions, mostly around the berm and blasting. Just to lay some background, you're the Vice President of Permitting and Land Acquisition at Michaels Road and Stone. Is that right?
That is correct.
And as I understand it, Michaels Road and Stone holds the lease to the mined property on which the P&Q Warmka quarry operates. Is that correct?
That is correct, yes.
And I believe you laid out some of your background in your direct testimony, but how long have you been involved in quarry operations?
45 years, 25 years with Michaels, 20 years with a different operator prior to that.
Okay, so it's fair to say you have a lot of experience with quarries.
A little bit, yes.
I'd like to talk about the preferred route a little bit, just to kind of understand what the berm construction will look like. And if we're looking at Exhibit P&Q Warmka LLC Bingen 1, which is quite a mouthful, we'll just call it your Exhibit 1.
So we should be referring it to PQW Bingham 1.
Oh, I see. Okay,
It'll be corrected with the refilings.
I see. Well, then it will be less word salad.
That's the point, yeah.
PQW Exhibit 1 is a diagram that shows where the alternate route and the preferred routes would go in and around the quarry. Is that a fair summary of what the exhibit shows?
Yes, it does.
And just so the record's clear, the preferred is it your understanding that the preferred route would actually encompass both the red solid line and the orange solid line that are parallel next to each other on the far east side of the P&Q West Quarry expansion area?
That is my understanding, yes.
Okay, so can you please describe, and if you want, I saw the exhibit, maybe that would be helpful, but could you please describe where exactly the berm will be constructed, in relation to the preferred route, assuming the preferred route is chosen?
We have a permit that requires us to have 100-foot setback from the right-of-way line from the road, from Highway W. Within that 100-foot setback, we are allowed to build a berm. Actually, we're required to build a berm for visual and for noise abatement. So it would be at least in part of what it would be underneath the preferred route or within the preferred route.
And that's what I'm trying to get. I'm just trying to understand a little bit more detail about that exact construction. So it sounds like you're saying the 100-foot for the berm would start at the edge of the road right of way, not the edge of the actual road?
At the edge of the road right away, yes.
Okay. And then it would extend out 100 feet, obviously. And that would be the berm area, so to speak. Is that fair?
Yes, yes.
And even if the preferred route wasn't there, P&Q Warmco wouldn't mine in the berm area. Is that correct?
We would not mine in the 100 feet, correct.
Okay. And are you familiar with the fact that ATC's proposed easement for the preferred route would be 150 feet total in width?
I don't think we ever got a definitive number from them. It varied. It was 115 at one point. It was possibly 200 at one point. So I'm not sure if they've decided exactly.
Okay. But if ATC says it's going to be 150 feet, you don't have any reason to dispute that?
Correct.
Okay. And I think I know what your answer to this is going to be, but I'm going to ask it anyway. So if ATC testified that only 115 feet of that 150-foot right-of-way would actually extend onto P&Q Warmca's property because of right-of-way sharing with the DOT, would you have any reason to refute that number?
No.
Okay. So assuming that's true, again, because you don't have any reason to dispute it, but you don't have any specific knowledge, if ATC's easement is 115 feet onto P&Q's property and the berm would be 100 feet, the difference in potentially mineable area would be 15 feet. Is that correct?
We don't know that. I think our only question is relative to the vibration limits that they will impose for distance to their structures.
Okay, so the primary concern is the vibration and blasting requirements with the preferred route?
It's that is again it's distance from it's whatever they're taking for additional right of way, but it is vibration, yes.
Okay. And actually, that's perfect segue because that's what I was going to ask you about. So, in your rebuttal, and I believe on Exhibit 4, which is some of the ATC guidelines you reference, it says, well, and this is from your testimony, ground vibrations near any ATC structure are not to exceed a peak particle velocity of 2 inches per second for frequencies greater than or equal to 40 hertz to minimize damages. Is that your understanding of what the ATC vibration requirements are?
Yes.
Okay, so 2 inches per second would be sort of the upper limit.
Yes, and that matches the permit requirements we get from the state of Wisconsin for all blasting. So
Okay, actually, I'm glad you raised that because that was similar to my question. So are you familiar with Wisconsin Administrative Code, the Wisconsin Administrative Code that deals with blasting?
yes.
And just so the record's clear, you can trust me on the number. I don't expect you to have memorized the number, and I can pull it up if Your Honor wants. But the code section is Wisconsin Administrative Code 307.44 sub 4.
What agency is that from? Let's go off the record. Just give me the site. I can
actually hold on a second. I have it pulled up here in a PDF. It is Wisconsin Administrative Code SPS, whatever agency that is, 307.44.
see what Google does.
Safety and professional services.
Yeah, there you go. That's it. And actually, Your Honor, just so everybody can see, there's a chart. You have to hit that little PDF button at the bottom of that section, and then you can pull up, not there, right at the, yeah, there you go. And it'll pull up the actual PDF that has the chart in it. And if you scroll down, there, that's the chart.
Are we back on the record?
Now let's get on the record. So we're going to just identify where we are, Attorney Potts.
Yeah, I can do that if you want, Your Honor. We're in Wisconsin Administrative Code SPS section 307.44 sub 4, and we're looking at figure 7.44.
Okay.
All right. Thanks everyone for your patience there. And my question is it your understanding, Mr. Bingham, that the blasting requirements for dwellings are similar to the blasting requirements in ATC's blasting guidance?
Yes.
Okay. And Your Honor, if we could go back to Mr. Bingham's Exhibit 1. And Mr. Bingham, the expansion of the quarry will be effectively directly east on the parcel that says P&Q West LLC, directly east of the existing quarry, all the way over basically to the roads and property lines, except around that one house. Is that correct?
That is correct, and we also own that house, so it would encompass that entire parcel.
I see. Okay, so you own the Brian Yone property as well?
Yes.
Okay. And so the blasting requirements for residences in this area would still apply to the residences that are near the quarry but just right across the road. Is that correct?
That is correct, yes.
Okay.
You're just talking about the Schoenberger property?
Yeah, and Mertz up at the top. But Yone, I guess, is not there. I don't have anything further. Those were my only questions.
I just wanted to have you clarify when Attorney Potts had asked the question of you, witness, is it Bingen?
Bingham.
Bingen, oh, sorry, okay. That, I think he said, do you understand if the vibration limits, this chart in ATC's guidance was similar to the chart provided through the SPS rule? And I just wanted to make sure, just want to give you a chance to explain in what ways, if you need to clarify that, or you've seen both of them, do they differ in any way that's significant to you?
That is the rule we have to follow for blasting and what vibration levels we're allowed to have up against structures. And it's a question about what structures may mean buildings, but in this case, we're not sure if it's being told that it applies to the towers also.
It looks very similar. It looks the same, these requirements though, don't they?
Yes.
Okay, all right. Okay, good, thanks. Okay, any other, so do you have cross from commission staff?
No, you're on.
Do we have any redirect?
No, thank you.
All right. I think that's it. Thank you very much. You're excused.
Thank you.
With that, Your Honor, P&Q Warmka is called as last witness.
All right, thanks. Can we move on to commission staff?
Yes, commission staff, in substitution for Kirsten Biefeld, who couldn't be here today, we're calling her Supervisor Katie Smith, from DATCAP.
All right. See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right. Go ahead.
Ms. Smith, can you please describe your position at the Department of Ag, Trade, and Consumer Protection?
I'm the Land and Resource Management Section Manager in the Bureau of Land and Water Resources at the Department of Ag.
Are you sponsoring the direct and sir rebuttal testimony of Kirsten Biefeld?
Yes, I am.
And are you also sponsoring the exhibit marked exhibit DATCAP AIS?
Yes.
Are the statements and representations in the testimonies an exhibit of witness Biefeld filed in this case true and correct?
Yes, to the extent of my knowledge.
Can you please provide an explanation on your role in sponsoring the testimony of Ms. Biefeld and appearing during this hearing?
Kirsten had a pre-planned trip during the scheduled timeline of the hearing. I was involved in the preparation and review of the testimonies in AIS in my supervisory capacities.
Are you confident in the professional opinion provided in the testimony and exhibits?
Yes.
Okay. And we'll talk about one thing first. Well, let's just ask the basic question. Are the statements and representations, or sorry, do you have any additions or modifications to the testimony or exhibits at this time?
Consistent with the discussion earlier, DATCAP would, I guess, make a recommendation to adjust one of or several of the bullets in the sir rebuttal DATCAP Biefeld, and this is on page 3.
So you're referring to the testimony of witness Lemire's on recall, correct?
Yep.
And he had indicated that ATC would be open to applying the order points proposed. It's pages 3 and 4 here on the screen. Thank you, Judge. He indicated that ATC would be open to applying those to the entire area if they included some flexibility for ATC. Is that what you're talking about?
Yes.
So does DATCAP agree that adding that flexibility makes sense?
DATCAP agrees, adding the flexibility makes sense. With considerations for bullets 1 and 3 to add the language to the extent or degree practicable. And then to acknowledge bullet 2 already includes restored to the degree possible, and that bullet 4 should incorporate that same to the either to the degree possible or extent practicable for the restoration of pre-construction function.
Okay, so DATCAP is revising its 4 recommendations here for those changes, correct?
To imbue the flexibility discussed, yes.
Great. And are there any other changes or additions that you wish to make?
Not at this time.
Thank you. Open to cross.
Okay. So this is I do believe we did know about this the unavailability of witness Beefield earlier on in the process, if I recall correctly, but we went ahead and scheduled the case as it is for all the reasons why we had to do that. But but since I don't know if we knew who this person was going to be who's substituting for her until I guess today, right? Or
I failed to inform the court of that substitution, but we
Oh.
knew it would be Katie immediately.
Okay, but did parties know then? Or
No, no.
Okay.
In the
So-
future, staff will let the parties know.
Okay.
Apologies.
So just should have an opportunity. I think it's probably past due, but if we have an opportunity for any objections to the substitution of the witness today.
None from P&Q, thank you.
I'm hearing from the ATC.
I think we said that at the same time.
Oh, okay.
Objection from ATC. I don't. JJ might want to go again.
And none from P&Q.
Okay, that's fine. And I don't think it's necessary at this point, but if in the future we just want to also provide background of the witness, education background, just and when we're introducing them, but seeing no objections, we don't have to do that at this point. So any cross-examination?
None from the applicants.
None from me, Your Honor. Thank you.
All right, thanks. All right, so we can accept those documents as they've been verified today, and we'll just need, I don't think there's any filings requirements we need to fix. So thanks very much. You're excused. Okay, next witness.
Commission staff calls Colton Bushy to the stand.
See you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Mr. Bushy, did you cause to be filed direct PSC Bushy?
I did.
And are the statements and representations in that testimony true and correct?
They are, yes.
Do you have any additions or modifications at this time?
I do not.
And are you also sponsoring the completeness determination exhibit, the data request exhibit, and the delayed public comments exhibit?
I am.
No further questions.
Okay. Okay, so that testimony is in the record. Any cross for
No cross from the applicants.
Okay.
And none from intervener.
So I did want to just review, maybe we just need a simple clarification here. I know I noticed on the data request exhibit, you want to go ahead and ask that Attorney Rogers? You know what
I do know what you're talking about. Mr. Bushy, are you familiar with staff's practice of strike-throughs in these data request exhibits? I know this one wasn't specifically prepared by you, but Judge, if you can scroll down and show us.
So there's the note here at the beginning, at the top, and it just indicates that original versions of revised documents are shown in strike-through. And then it does list one in particular. There may be more, but the one that to my attention was a DNR. Oh, am I missing it?
Witness Bushy, well, you didn't prepare this one in particular. You've prepared these before, and I think you can explain the purpose of that strike through.
Here we go. Yeah. In particular, this one I noticed was stricken. Yeah, if you know what that means and how it affects the exhibit, just let us, can you clarify that?
I have prepared these before. I believe that the reason for the strike through is that there was a more up-to-date version of this response that was filed, and the strike through was made to show that there was a more up-to-date version that is more accurate to use.
Okay, so the revised, so it says revised response below attachment data request WDR DNR WN 1.4, and that is replaced by the revised response. Is that how you would interpret that strike through?
Yes, that is how I would interpret it.
Okay, all right, just wasn't sure. Thanks.
And Judge, in the future, is your instruction to staff to just remove that entirely?
So I don't really regulate this document as much as others because I don't know how staff uses it. I don't want to hamstring it if it needs to keep those lines in the document. I guess the best practice would be to create a different document where they would not have the strike through lines that we receive as the exhibit. Perhaps it may be just to indicate in the key here a little bit more, just to say, you know, they're not, those strike through documents are not being offered for the record. And if it needs those in this document for its own purposes, I'm not really, don't feel really too strongly about it. As long as the commissioners and, you know, the record and the returner record is clear that those documents were not reviewed by the commissioners or were not used to make the decision. Another option would be to take the live link off, so that commissioners in particular couldn't link to that document and read it. So there's a number of ways of doing that. I don't really feel the need to actually order one way or another, but those are the options, I suppose, as long as we can clarify to a greater degree that we're not receiving those documents for the record.
And Judge, do you require a revised version of this exhibit to be filed with one of those solutions?
Sure, why don't we do that? So just pick a solution and file it.
Okay.
Yeah.
Thanks for clarifying that, Judge. And I don't have any more questions for Witness Bushy.
Thanks. All right, any cross?
None from P&Q.
Nothing from the applicants.
All right. You keep your mic on, this way you could get up to the punch. All right, next witness.
Our next witness is Weston Matthews from DNR.
Okay, see you there. Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Witness Matthews, did you prepare and file or cause to be filed direct answer rebuttal testimony in this docket?
Yes, I did.
Did you, I'm sorry, scratch that. Are the statements and representations in your testimony as filed true and correct?
Yes.
Do you have any additions or modifications at this time?
No.
Open to cross.
Any questions?
No cross.
And none from P&Q.
All right, thanks. You're excused.
Commission staff calls Jessica McDonald to the stand.
Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Did you prepare and file or cause to be filed direct testimony in this docket?
Yes, I did.
And did you also prepare and file or cause to be filed the exhibit PSC, or exhibit PSC EA?
Yes.
Yep, it's there. Great. And are the statements and representations in the testimony and the EA true and correct?
Yes.
Do you have any additions or modifications at this time?
I do not.
No further questions.
Okay, Cross from ATC
No cross.
and PQW.
No, thank you.
All right, thanks. You're excused.
May I call our next witness?
Yes.
Commission staff calls DNR witness Stacy Rowe.
All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Did you prepare and cause to be filed, or did you prepare and file or cause to be filed direct DNR Rowe?
Yes, I did.
Are the statements and representations in the testimony you filed true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
No, I do not.
No further questions.
All right, questions from ATC?
Yeah, I just have a few questions for this witness. Good afternoon, Ms. Rowe. My name is Brian Potts. I'm representing ATC today. I just have a few questions about your proposed tree clearing restrictions, which you've identified in your direct testimony on page 5, lines 14 through 21. Wow, you're fast, Your Honor.
Read your mind.
Yeah, the on your direct testimony that's up on the screen, you state that the DNR recommends a period of April 1 through August 15th as a longer period of no tree clearing. Is that a fair recommendation of your, or fair summary of your testimony?
Yes, it is.
Are you aware, well, have you been involved in previous ATC projects?
Yes, I have.
And are you generally aware of ATC's mitigation procedures related to roosting bats and birds?
If you're referring to the document mentioned in Beeman's testimony, I don't believe I've seen that before.
I guess I was just more generally, are you
Generally, more or less, I believe so. I guess you'd have to be more specific.
Yeah, okay, I can be more specific. I was just trying to understand your background a little bit. So are you aware, Ms. Rowe, that ATC is planning to conduct habitat reviews of the right-of-way prior to clearing the right-of-way to ensure that there are no nesting birds in the right-of-way?
I was not aware of that, no.
And if that is the case, would that reduce your concern about tree clearing during this period of time, if indeed ATC is, prior to doing any clearing, doing habitat reviews to look for nesting birds?
Yes, it would.
And your testimony here is limited, or I guess, let me back up. The DNR's recommendation related to tree clearing is based solely on the potential impacts to bats and birds. Is that correct?
Yes, that is correct.
Okay, so DNR has not considered, for example, whether implementing that recommendation would delay the in-service date or any impacts associated with that?
I did not consider that. I was only specifically looking at protecting, in general, birds and bats.
Okay, nothing further, Your Honor.
Any other cross?
Nothing for me, Your Honor.
Okay, thanks. Okay, any redirect?
Yes, Your Honor.
Okay.
Witness row, what would you need ATC to provide for you to be comfortable that they were planning to conduct habitat reviews to look for nesting birds?
I suppose if that was stated in their protocol document, that would be good enough for me.
I don't have any further questions for this witness. As a sort of, I guess, housekeeping matter, is it possible for us to reserve a exhibit? The attorneys identified a potential document. If we could get that in.
Yeah, I don't know that we need a new exhibit. I believe that information is either already in the record in the application that they'll be doing the habitat reviews, or will be provided as part of the avian protection plan, which I think is done after the order is issued. But I'd be happy to, if you want to create an exhibit, we could create an exhibit, and I'd be happy to have someone from ATC, provide what is effectively a data request response that says what they will do in the right of way as far as habitat reviews go. And that way there'd be evidence in the record.
The avian protection plan would be appropriate. I've seen those before, and I think that would be an appropriate document to have that in.
Yeah, I just don't think that gets done until after the order's issued and they work with the DNR, is my general understanding. So we wouldn't be able to get that in before the order. So I was just saying, if it's important to the DNR's, understanding of what's going to happen, we could have ATC put in something in an exhibit that says what their habitat review protocol will be during construction, and that would then put it on the record.
That would work for me.
Okay.
So just to fully close the loop on this, Judge, witness row, in anticipation of the documentation that Attorney Potts is provided that we see that documentation timely, is it accurate to state that you're revising your position to no longer recommend that longer tree clearing period going out into August 15th?
If during that time frame they plan on doing those assessments and determining that there are no active bird nests within the trees and shrubs that they plan on clearing, then yes, I'd be good with removing that order point.
Well, let's mark anyway, so we have an exhibit placement for this would be exhibit ATC Beeman 1. And I think we had a lot of description about what that is already stated. Hopefully, I think the witnesses and attorneys know what that is at this point. But essentially well, is the
I think it's
plan? I guess that's.
Yeah, I think it's a procedural statement, or a statement about the procedure that the applicant is committing to follow. It's sort of in lieu of testimony. I mean, perhaps this is something that witness Beeman, if
yeah, I mean, we could just recall Miss Beeman, but she's probably not wouldn't love that, but it would be more efficient.
And who says we have to consider their desires? So let's say I did have a question though for current witness row about the studies that you're thinking of would need to be conducted during that period of time that you're asking, that your current testimony asks for no clearing through to August 15th. So when would the study need to be done?
I believe I recall ATC stating that they would have no clearing until mid-July. I think it's July 15th. And so between July 15th and August 15th is when we'd want to evaluate the vegetation to ensure that there aren't any active nests present within the vegetation that they plan on clearing.
So there'd be no clearing until this, but there could be no clearing until after the study is done.
Yeah, I think we should maybe ask Ms. Beeman the details because I don't want to commit to something that's incorrect. But my understanding was that ATC will do habitat reviews of the right of way prior to clearing any of the trees and will look for nesting birds. In fact, of all types. That's my basic understanding, but maybe we should just ask Ms. Beeman.
Okay, so why don't we just have you stand down for a minute, witness row. We'll recall witness Beeman to get better understanding of this. So I see you there, witness Beeman. Recall you're still under oath, and I think I'll have Attorney Potts take the first shot at getting the information we need because he's your witness. So let's try.
That's fair. Hi, Ms. Beeman. I guess, can you just generally describe the process that ATC will use prior to tree clearing to ensure, protection of nesting birds?
Sure. Could I first clarify the restriction that's noted in testimony is for oak wilt?
Yeah, there are two different restrictions that we're talking about here. One is oak wilt, which is not what we're discussing, and then the other one is the DNR's statement that we
Sure.
should.
I just wondered if that was what Ms. Rowe was maybe referring to with the July timing that she referenced. But to get back to your question, we will, assuming, because it's a broad restriction, so assuming there is habitat for migratory birds, in the areas designated to be cleared, we would, to the best of our ability, survey for active nests and mark those and avoid and monitor those nests until fledging.
And that's true for the, obviously there's not necessarily going to be habitat across the whole project right of way, but that's true anywhere there would be habitat, potential habitat in the right of way.
Correct.
I have nothing further. I think that answers the question, but.
Okay, so how are we doing? Do you have any more questions on this for witness Beeman?
I think I might have a question. Witness Beeman, is there a documented policy that speaks to this practice of habitat reviews for nesting birds before construction projects? Anything in writing?
Yes, it is in our avian protection procedure, which is modeled after the APLIC guidance.
I'm sorry, after the what guidance?
APLIC guidance, which is the Avian Power Line Interaction Committee.
Thank you.
ATC is a member, and there are partners such as U.S. Wildlife Service.
Witness Beeman, can you repeat the name of that document?
The ATC document is Avian Protection Procedure.
Okay, and is that one in evidence?
We have not provided it as part of this docket. I referenced it in my rebuttal testimony to Ms. Rowe.
So maybe we should add that as the exhibit, if you'd want.
I think so.
Is there any I mean, we could file it confidentially if need be. I don't know if there's any
If need
confidence.
be.
I think there is. I think it has been filed confidentially as part of a different docket.
Yeah, we can file it
Yes.
confidentially as exhibit, as Miss Beeman's exhibit 1, assuming your honor's okay with that.
That was going to be my suggestion. I just wanted to find that in the testimony and the reference
Rebuttal.
to the rebuttal. Yeah. Wasn't cooperating with me at the moment. So,
Page 2.
oh, oh, management kind okay. So it's the Oak Wilt. No, it's Oak Wilt. Oh, okay. Avian protection plan procedure. Yes. So yes, we could just have you file the ATC avian protection procedure as your exhibit 1. And do we need any further reporting then that we were discussing before? I mean, this potentially we could leave that to a report of sort of like a data request response, if that maybe makes handling the document a little more flexible. This is in terms of the information as to when the testing is going to be done, or we were discussing that before as
Yeah.
having to file something. So
Yeah, I mean, I just have to say this is a little frustrating because we, this we're at the very end of our hearing. This would have been really helpful to have earlier, but we are trying to make this work. Having that generic policy broadly applicable avian protection procedure is going to be useful. And then I think that we can work out some kind of interim reporting through data requests. And when can we have more details on that? Witness Beeman, when will you know the schedule for the habitat reviews?
Well, it would be, I think that might be hard to know based on the schedule and, it would be prior to the vegetation management scope, but, we would need all of our real estate documents in place.
Would it be possible to file some kind of statement just committing to following those avian protection procedure protocols? Just to just
Yeah, we could even put that in her exhibit. That
I think the witness is making that statement in testimony.
Okay, right. You're right, Judge. Thank you.
But we could, since this has been raised, and there's obviously controversy about it, it could be something that we have the applicant report on, by a certain date and then update in a certain frequency, because we don't really know what date they're going to have. So if we have something that catches them, at a certain frequency, interval frequency, we could, have them report at the time that it becomes available.
Okay.
Yeah, we could, I mean, I assume there could be an order report or something that says, let us know when you're planning to do the habitat reviews. Or I guess I'm not sure what you mean by reporting. It's, as I understood Ms. Rowe's testimony, she wanted us to commit to doing the habitat reviews prior to clearing, and I thought that's, Ms. Beeman already did that. And so if we were just to put the procedure into the record, ATC's already committed to doing those habitat reviews, and so I'm not sure what reporting would be necessary.
I guess
But
it's just a little tricky because we haven't seen the report of the procedure yet, you know, the actual document, so we don't know exactly what it's guiding ATC to do. And then given that in terms of the other guidance documents we've seen, they may not be requirements of ATC. So I don't know to what extent we can, I mean, I think that the witness is committing to it, but you know, maybe a statement that in this case, ATC will follow this procedure. That might be useful. So I think I am seeing you in that regard. So
And that is in testimony
yes.
here.
But
Okay.
we just don't know what it said, what the document
Okay.
actually says. So that's
I mean,
Judge-
is it, I mean, because she is in this testimony actually committing to follow it. We don't know what's in it. So if we file it within 3 days, the commission, if they had questions, could issue data requests, I think.
I think that's fair. Just we don't know. Yeah. I mean, we don't want to stretch this out too far. But yeah, I think we can leave it up to the commission to follow up with any further questions once the procedure's on file. Yeah, and I would just recommend that if you're citing a procedure, well, I mean, I think generally speaking, the commission just should have all of ATC's procedures on file, so we can always be able to refer to them. It's always sort of a game of fishing to kind of figure out what ATC does and what's guiding it. But in this, you know, we're citing this one, so if you're going to cite to one and rely on one, you probably should get it in the record. So this way we know exactly what you're talking about, and staff can follow up if they need to, if they feel that there's a need for clarification. So I think we fixed that problem here. So we can move on.
Judge, there is, I do have a couple other questions for this witness.
Okay.
One is just whether ATC would report on any nesting birds that were found and avoided. So let's, I think we can anticipate a data request asking for those reports. And is that going to be a feasible ask? I'm just asking.
I do not believe we've had that ask before. Yeah, I don't think I can speak to the feasibility right now. Yeah, I believe we could. I believe we could.
Okay. We can continue to explore that in data requests, and we can talk offline, and then can you we haven't seen this procedure yet, and so I don't know how close it is to the US Fish and Wildlife recommendations. But can you maybe provide a comparison between the avian protection procedure that ATC has versus the US Fish and Wildlife's Migratory Bird Treaty Act guidance?
You're asking now for the witness to explain that, or?
Yes, I am.
I can't do that now.
Well,
I do know that it's that we are a partner with APLIC, are a member, and the U.S. Fish and Wildlife Service is a partner, and they have guidance available that our procedure closely follows. That
Okay.
is what I know.
Okay, and so it's close, if not completely following.
Yeah, we are
Protocols?
active members and contributors.
Is that a publicly available document, the U.S. Fish and Wildlife's?
Well, I do know that APLIC's guidance is available. I think they may want you to be a member or partner to access it. I mean, I will just say that we do maintain all of our current mileage of transmission lines following our procedure. It wouldn't be feasible to follow that restriction broadly for all of our maintenance activities.
What's that restriction? The ATC procedure or the Fish and Wildlife?
The restriction of the April 1st through August 15th.
The DNR recommendation, the original DNR recommendation, I believe.
Yeah. Okay, and the Fish and Wildlife regulations are generally followed?
Yes.
But we'll see more in the avian protection procedure.
Yes.
Okay, I think that we have enough here, Judge, to move on.
Yeah, okay. All right. So yeah, I think and I think that the conditions in this that get ordered in this case will be particular to this project. I think that's whatever order conditions are in this or that come out of this proceeding will be particular to this project. That's I don't think there's a concern about ordering every maintenance activity to follow these dates, but at least not in this proceeding. So
okay,
that's a helpful clarification, Judge. If I may, can I just ask one more question following on that? Witness Beeman, understanding that the recommendation would only go for this project, can you please comment on the feasibility? And if you've already addressed it, I would withdraw my question, but I want to make sure. Can you comment on the feasibility for this particular project of following the DNR recommendation?
I think that really gets to schedule and project management, and I would defer to witness Lemire and for that answer.
And Ms. Rogers, there is definitely testimony.
Yeah.
I can't point to it right now, but there's definitely testimony on that issue.
Yeah, I know there is on the Oak Will. I'm not. We can move on from this.
okay, all right. So yeah, I think getting the protection procedure on file is going to be helpful, and then we'll leave it up to staff to take it from there.
Maybe just one more comment that devices such as the bird flight diverters, use of those is also something that is in our procedure, and we are, designing for on this project as well, to be protective of waterfowl and migratory birds.
Okay, yep, appreciate that. Any other questions, cross questions? Redirect for witness Beeman.
Nothing for me, Your Honor.
Okay. So we need to recall witness Rowe. I didn't forget. I don't know if we have any further questions for this witness.
Yes, Your Honor.
Okay, go ahead.
Witness Rowe, did you follow along that testimony from witness Beeman?
Yes, I did.
And does that testimony change your position on the tree clearing recommendation?
My recommendation would still stand, but if they do show that they're going to be doing these assessments ahead of time during the time frame that I suggested, then that we would not need an order point to have no tree clearing during that time frame with regards to birds and bats.
So unfortunately, we're at a stage of the proceeding where it's tough to have you revise an order condition any further. So just to make sure we are understanding the proposal, are you standing by your order point as proposed until the time that you review the avian protection procedure? In other words, is your this is a funny procedural question. If we can get that procedure in the record and you review it, will you, Judge, I'm a little bit at a loss here. I guess we can let this just lie the way it is. I'd like to clean it up, but I'm not quite sure how.
Yeah, well, I think we have the order condition, the proposed condition, as with the rationale and evidence provided by witness row, and we'll have the avian protection procedure on file, and the commission can then can weigh the two and see if an order condition is necessary. I mean, that's if nothing else changes. We don't have time. I mean, if there's enough time and witness row is interested in changing her position on the order condition, I guess we can hear that. I don't know what process we would have to give it, perhaps in an affidavit, removing the need for the order or the request for the order condition. But I think the way it's been set up, I think the choice is clear, and the commission can weigh the two see if it's needed.
Thanks, Judge.
Best we can do at this point.
Yeah, Your Honor, I don't have any concern with, I mean, we've done the best we can, I think, and there's clearly evidence on the record about this. So I think there should be enough for the commission to make a decision. And certainly we wouldn't oppose, obviously, an affidavit later if Ms. Rowe decides she wants to, change that order condition.
Mm-hmm. Yeah.
Okay. Thank you.
All right. So have all our questioning of witness row concluded? All right.
Nothing further.
Thanks very much. You're excused. And all right. So is that the balance of witnesses? If so. All right. So we're nearing the end. I think the last thing we need to address is simply stating that we have a briefing schedule, post-hearing schedule already established in the scheduling order, which includes those three working days to refile and file what we've identified as the new exhibits. Yeah, and these can all be refiled. These can all be sent in by the deadline, right? The Lemire exhibit and.
Yeah, that should be no problem.
Okay, I can't recall if we said
Except possibly the Lemire exhibit, because you remember that was the one about we need to know where the laydown yard is, and it might take a couple weeks.
All right, okay. Yeah, I knew that. I thought there was something different with that. So we'll be looking for Beaman 1, the refiled application. So it'll be R4, and and then let me just make sure we're clear on the PSC public comment exhibit. So far, in terms of written comments, we have, I think this was as of yesterday, we have 3 filed in the case. within the notice of hearing timeframe. So I wouldn't, if I'm speaking correctly here, unless I get more than 5, I'm not going to have us create the public comment exhibit, but we'll have the transcript from the public hearing. The exhibits that are listed here on the offered evidence list will be put on the received evidence list. And the written comments we received in the public hearing will also be filed as public comment in the case. So we'll see how many we get total. And otherwise, I think that's it. Anything else we need to address?
The one question I had, and maybe I missed it at the beginning, but did we make sure the application and all the data requests and responses are in the record? Does that just happen automatically? It used to be we had to like move them all. I just wanted to make sure everything is buttoned up there.
Right. So all the documents on the list are in the record, but we just need to get the revised versions in. So that'll be, that includes the application exhibit. There seems to be new documents we need to add to that list, right?
Yeah, we'll revise the application, but I didn't know if the data request responses are on there too.
Well, the data request responses that are on the data request response exhibit are offered.
There is an exhibit. Okay, perfect.
Oh yeah, we discussed that. Remember, we had that up on screen.
Okay,
the strike through, yeah.
Okay, I got you. Thank you, Your Honor.
That was in there. All right, and yeah. So anything else? Right. Thanks very much. We're adjourned. Take care.
Thanks, Your Honor.
Thank you, Judge.
Thank you.